Is allowed.
46.
Petition is allowed.
47.
Petition is dismissed.
48.
Petition is dismissed.
May I please, Your Lordship? Also, I beg to mention item number 20, Your Lordship. In this case, we have taken stay upon the father of the victim, Your Lordship. Service report is awaited, and scan copy of TCR is also not received, Your Lordship. The date will be fixed after the review vacation, Your Lordship.
Service report is awaited. Here is also awaited. Begin on.
I beg to mention for item number 25 and 42, I am for the victim lordship for taking the affidavit in opposition filed by me lordship. With two items.
25 and
42.
list on the prayer of learned counsel for the respondent number 2.
Victim lordship.
Victim.
Yes. I have not met in party, I am victim lordship. I am for the victim.
You are not yet a party.
So, lordship in FIR, lordship, I am victim. FIR has been lost by my elder brother. I have filed a affidavit in opposition in that BA and AB, item number 25 and 42.
You filed a affidavit in opposition on behalf of whom? The respondent.
Lordship, for the victim, lordship.
Whether the victim is a respondent or not.
Lordship, in bail, AB and BA, they have not met me party, lordship.
Call up the items. No adjournment. Next.
Yeah, PG Lordship. So item number 57, Lordship, additional affidavit file your that is not in record, Your Lordship, that may be called for, Your Lordship. Item number 57, Your Lordship. Much.
Please, Your Lordship. So, pray, if with time permits, Your Lordship, to take up an unlisted matter, my lord. It's an anticipatory bail application, POCSO, so only notice will go, my lord, if time permits, my lord, as the last item.
Whether it was rejected by this court.
Only Your Lordship is taking up the special act roster, my lord. I'm deeply aware.
Please, Lordship. Lordship, supplementary list, item number 50, Lordship. The reply is ready, but we are ready, waiting for the final approval.
Item
50, supplementary.
is what is ready.
The reply is ready, Lordship.
So file.
We're waiting for the final approval. Waiting for more time, Lordship.
Inform the other side.
CBI.
Your CBI. What about petitioner?
My lord, I am there for the petitioner.
He's taking
Kindly
time.
have the matter, my lords. It's been 58 days, my lord. 58 days.
Okay, we'll call up. Since there is objection, that will be called up.
May I please, Your Lordship? Lordship, I beg to mention item 32, Your Lordship. Both the councils of this matter, Your Lordship, is currently out of session due to voting purpose, Your Lordship. Election
30? 32.
32, Your Lordship.
The prayer of learned counsel.
Your Lordship, there is an interim which may continue, Your Lordship.
Interim. The next day.
And Your Lordship, one thing, Your Lordship, in this matter, CD is available, Your Lordship. So till the next date, CD may be retained.
It be retained till the next date.
Highly blessed.
May I please, Your Lordship? Lordship, I beg to mention item number 17 for withdrawal.
Yes. All right, 17 on the prayer of the list. Again on.
Withdrawal.
Yes,
I beg to mention for item number 40, my lord, may kindly take this matter after view vacation, my lord.
item 40, after
4040, my lord.
40.
40.
Date may be given, my lord.
Yes,
Lordship, I seek permission for item 24 for withdrawal, Lordship.
24.
Yes, Lordship.
Your name?
Lordship M. Bhuya.
The prayer of MS M. Bhuya, learned counsel for the petitioner. Matter is dismissed as withdrawn.
Lordship.
Next page, Lordship. I think 41, my lord. Perhaps CD is not available, my lord. I have been informed. So some other
You want CD not available, list again on. And so,
interim may be continued. my lord.
hearing order passed earlier to continue till the next.
Also.
May please, Your Lordship. My lord, item 38, my lord. This matter may be taken up after vacation, my lord.
38
Item 38,
after vacation.
vacation. Early of less, Your Lordship.
Item number 49.
So on instruction, I may be allowed to withdraw this petition, Your Lordship.
Yes, on the prayer of your
F. Hussain, Your Lordship.
S. F. Hussain, learned counsel for the petitioner. Mr. is withdrawn.
Deeply obliged, Your Lordship.
My previous lordship, my lord, custodial period is 58 days as on date. My lord, this court had early rejected my anticipatory bail application on 29/20, 9/1/26. My lord will find it page 71. Subsequent to that, my lord, I had surrendered voluntarily before the learned CBI court, and I was taken into custody, and since then I have been languishing in judicial custody. My lord, 58 days is the current detention period.
Final report has been submitted.
Not to my knowledge, my lord.
It will be so, yes.
No, no, no.
Yes,
So, my lord, the allegations, my lord, will find from there are two FIRs. The first FIR, my lord, will find at page 26. May I read the FIR, my lord?
no, before we go into the merits,
My lord.
just let us know the current status.
My lord, since we had surrendered before the CBI court, we were taken to judicial custody, and our police custody was sought for 5 days. We were granted the police custody, and since then our police custody has never been sought for. That is the current position. 58 days, my lord, is the
What is the statutory period?
60 days, my lord.
And what is the status of the charge sheet and filed?
May I please your lordship? Earlier also they have filed this case, an application for regular bail. That was rejected because he was absconder since long. He was granted a bail on the condition that he will appear before the chief judicial magistrate at Dhubri somewhere, but he has jumped it. Consequent upon which thereafter the matter is transferred to the CBI. CBI has taken the investigation, and due to their absconding, our investigation could not be completed. When they have come with the regular bail is rejected, then he surrendered there. Now the investigation is going on. His one of the colleagues, Sanjay Bhagat, is still absconding. Though the charge sheet has been filed so that he may not get the default bail, but we are in search of Sanjay Bhagat, who is close associate. And as of today, sir, though our objection is ready, but it is not approved by the higher authority, we could not able to file today. So I am requesting for 10 days time to file the reply.
The charge sheet has been filed. So no question of default bail now.
Yes, now,
Just a.
to avoid the default bail. However, his
My lord,
close
how is
associate,
it possible, my lord? There's
his
an
close
investigation is
associate,
going on.
Sanjay Bhagat, he was absconding from 1.5.
Contradicting
Yeah.
evidence, my lord.
No, lordship, your judgment can reveal the.
No,
the
anyway,
passed
this is
by
for
this-
motion.
Yes, my lord. No, my lord. On the last day, my lord, they sought time for filing their instructions. I mean, their written objections. My lord, the
I
order
may
will
be
find that.
completed few days time to
27th,
file
my lord.
reply, your lordship. I was not there. I was on leave, your lordship.
My lord, may I kindly have the order dated 27/3. And my lord, contradicting submissions are being made. Once investigation is complete, how can charge sheet be filed without?
Investigation is not
being
yet completed, your
See, my
lordship.
lord, then
Investigation is
they are
because
themselves
Sanjay
admitting
Bhagat is not
investigation is
there.
not complete.
His close
How can charge
associate,
sheet be filed?
his close associate Sanjay Bhagat is not yet. He is also absconding, your lordship.
So in that case, my lord, how can
No,
charge sheet?
investigation in respect of some other accused may continue, but as far as you are concerned, charge sheet has been submitted. Is any investigation
No,
continuing in respect of the
investigation is
present
pending
petitioner?
because of his close associate Sanjay Bhagat. It is already there in the FIR.
We have heard that 10 times. Please answer our question. Is the investigation in respect of the present petitioner is complete?
His further investigation is pending because he is not available. And he was only our investigation could not be completed because he was absconding from last 1.5 years.
But my lord, we voluntarily surrendered also.
Because
aspect
he
also
did not get the bail, your lordship.
Yes, that was the anticipatory bail application, and then we voluntarily surrendered.
So my
Our intention is
submission
not to
before
evade
I
the
may be
process of law.
permitted at least few days time to come with the detail, every detail. It is a trade scam that has been transferred from the Supreme Court, your lordship, for the purpose of investigation. Thousands and crores of rupees are involved. And he has already jumped the order of the West Bengal court's order, where he has been granted bail.
Subsequent to that, my lord, I voluntarily surrendered before the CBI court.
That detail is, we will come with the detail, your lordship. There was a 2-3 cases, one in Tamarhat cases is also there. That is in the district of Dhubri. Sanjay Bhagat is there in page number 40. They'll come with the detailed reply, parawise reply to that effect, your lordship. Because the moment he will be released, he is having a close associate with Sanjay Bhagat, and the want of his presence, investigation could not be completed, your lords. And in the FIR, Sanjay Bhagat name is there. There are already 2 state FIR, your lords.
When did you file the charge sheet?
Few days back, your lordship. That is why I need instruction. Some few days back, so that he may not get the default bail, to avoid the default bail.
My lord, what a candid confession.
What is there in the matter of record? I cannot deny, your lordship. The date will reflect in the charge sheet.
No, see, so if we record your statement that the charge sheet has been filed only in order to avoid default bail,
My lord.
even though investigation is not over, what order do you expect from us?
I don't want to.
You are
lie.
already on record, in fact.
I don't want to. What is the further investigation is already there. It is a trade scam going on all over India, your lordship.
You're not making any sense, counsel. Let you get information on which date you have filed the, get on the phone, get the instruction. We'll take it up at 2 again.
CDA was called for 6/4, but CDA not received to them.
Motion. My lord, the matter is, my lord, listed on my lord on last day before yesterday, my lord. Yeah, and your lordship was pleased to fix the matter today
Not today.
in motion, my
He
lord.
was not called for, I think.
Ah, yes.
In this case, my lord,
How many days?
my lord, he is arrested on my lord 26/3, my lord, 26.
Yes, CD.
My lord, kindly have a look at page, my lord, FIR, my lord, at first, my lord.
Yeah, what will do?
My
Without
lord,
CD, will-
tomorrow's, my lord, is my lord. My lord, there is nothing FIR, my lord, in the FIR, my lord.
but nothing.
My lord,
If PP concedes, we'll see. PP concedes there is nothing against you, then we'll.
my lord, in the FIR, my lord, just, my lord, 2 lines FIRs, my lord, there is nothing, my lord, there is no any malicious, my lord, intention of the petitioners, my lord, and there was no any eyewitness, my lord, and nothing has been recovered from the, my lord, their own house, my lord, and nearby found something, my lord, some remains of that, my lord, has been recovered, my lord. Kindly have a look at page, my lord, 16, my lord, that is vernacular, my lord, page 16.
Details in forwarding report, page
Madam.
18 and 19. 19 the
Forward-
grounds are given, madam.
And my lord, the petitioner, in fact, my lord, in the FIR itself, my lord, reveals that, my lord, there is no any, my lord, enmity between the, my lord, petitioners with that of the informant, my lord, and there was good relations, my lord. My lord, in that situation, my lord, and third person might have been, my lord, arrived, my lord. And under that institution of third persons, my lord,
Yes, PP, you want to submit something?
The grounds, that has been given in,
Yes, we have seen, but
all the options, that is there.
how many days now? 14 days, I think. 14
My-
days. But had done it, counsel for the petition and done it. An application on the so and so. The allegation against the petitioner is that he left some portion of cow head and skin in front of the informant's kitchen door. And on asking, that is the accused, told the informant that his family member had left it there. So the petitioner was arrested on 26/3/26 and by now has spent 14 days in custody. Taking in view the nature of the allegations, further detention is not considered necessary accordingly. 20,000 one surety.
Chief Judicial Magistrate, Kokrajhar, my lord. Chief Judicial Magistrate, Kokrajhar, obliged, my lord, much obliged.
But this one is connected with item number 11,
The
perhaps wrongly given.
case record was called for, my lord. In fact, the case record is tagged with item number 11, man.
But we'll take it to item number 11 then.
But the matter are different, my lord.
Hmm?
The matter is different, my lord.
Matter is different.
Different. After some time, he may go through it, my lord. After some time.
Made pleaded lawsuits, my lord. In this case, I have filed one IA to implead the informant, my lord. It was listed on before yesterday, my lord, but I inadvertently, my lord, I couldn't make the party. That's why I filed one impleading petition. Here, lawsuits kindly peruse the FIR.
But IA 386.
Yes, madam. IA is 386, 2026.
In the IA, you write the IA has been prepared for implement of the victim of the case as respondent number 2, informant of the case as victim number, as respondent number 2. That is in the connected bail application being AB 719 of 2026. Prayer is allowed. The name of Daya Ray, wife of so and so, even be treated as respondent number 2 in the connected AB 719 of 2026. I stands disposed of accordingly. Now you have to file application
Yes.
for correction of course title.
Yes, madam. Madam,
That can be, she may file corrected cost title, my lord. IA is allowed. Correct, cost title has to be filed. Corrected secretary बोलेगा.
But in this case, my lord, the bail application, my lord, AB, FR is page 14. The girl is recovered on the same day, my lord, and the incident took place 23/10/2025, my lord. But FIR lost 25/12/2025. And POCSO was also added 2026 January, my lord, later on. And the girl was recovered on the same day. Same day in the evening, of course. And the petitioner is a student, my lord. He fall in love with the girl, my lord.
It is recovered on the same day.
Same day, my lord. 23/10/2026. When incident
FIR was lodged on 25/12.
25/12/2025. And
What is the reason for that?
and POCSO also, my lord, it is added in the year 2026, January. I have annexed the order. 28/1/2026. Everything is afterthought.
It had learned counsel for the petitioner and her application under so and so. The application is reflected in the FIR that 23/10/25, the at about 8:30 AM or PM?
AM.
AM. Minor daughter of the informant aged about 17 years went missing. Is further alleged that the petitioner, your petitioner, only one petitioner,
Yes, my lord.
lured the victim, the pretext of love, her to the house of her maternal uncle, his maternal uncle, and kept her there. The victim girl was recovered on the same day, but FIR was lodged on 25/12/5. Call for the CD also issue notice to the newly implemented respondent number 2. Provided the interim that event of the arrest of the petitioner, he shall be released on interim bail of ₹50,000 with a surety of like amount to the satisfaction of the arresting authority. Connection with the aforesaid case. It is further provided that the petitioner shall appear before the IO within a period of 14 days from today and cooperate with the investigation. And further, petitioner shall not try to influence the witnesses in any manner. Fix again on
Oblige your lordships.
Yeah, please. This is the second bail, if you please include earlier rejected on 24/3 in 26 minutes. The medical ground, my lord, he is trying a second bail application. Please, my lord, should call for the CD, my lord.
all right. CD.
CD and notice, my lord.
Notice.
Correspondent number 2.
But fix it immediately after the
28. Hey, both are
20.
27.
Probably.
May I please your lordship? Contacting counsel MISN is another court. Kindly pass over the matter for the time being. Obliged.
What is this?
Yes, sir.
The Witch Hunting Act.
This case, my lord, already search is submitted, my lord. Now, my lord, the trial court has, I've gone to the scanned copy of the record, my lord. Trial court has already issued summon, my lord, to the accused person, my lord. Now, the petitioner herein, my lord, they all have been shown as an absconder in the search, my lord. And as part of the Witch Hunting Act, my lord, the anticipated bail is, there is a bar under the said act, my lord. Is bar, my lord. So that is why they have filed this writ petition, my lord. Some protection, my lord.
I will appear, my lord. We will appear. And your lordship kindly direct on our appearance, we may be granted bail.
Bail, my lord, that protection, bail cannot be granted, my lord. Let them appear, my lord, before the trial court.
No, if anticipatory bail, there is bar to grant of anticipatory bail.
Under CRPC, now
Under the
under
said act.
VNS. Therefore, this is a writ petition, man.
So
And it
what
is-
we cannot do directly, we have to do indirectly.
Yes, that is,
Only for
that
the,
is-
only for the speedy trial, my lord, because they have all have been.
yes,
on
we
the.
will cooperate the trial, my lord. I can give assurance, man. We undertake that we will cooperate the trial, we will appear, my lord, but we may be protected, my lord. This is my humble submission. And your lordship, may kindly peruse the FIR, my lord, at page 21 is relevant. Here, my lord, against one Rajiv Madhok, the worst act that is done is by one Rajiv. He is not before your lordship.
No, first, we have to be satisfied whether we can interfere under 226 when there is
Sir,
an.
that is already held by the division bench.
Where?
The first order, my lord. First order. It was initially came up before the division bench, and division bench held that it is maintainable.
Peruse the FIR, my lord, the FIR will clarify, my lord. I think more petition on.
For mental liberty issue is concerned, it is already settled. Now the question is granting bail. It is-
Paragraph 5, which says, however, we do not give our conclusive verdict on the matter. What does that mean?
That means on the merit of prayer. Bail petition is maintainable. It is held that man petition is maintainable. Now whether bail will be granted or not, this is upon the court while matter will be.
My learned friend will have to satisfy, my lord, that bar is absolute or, my lord, it can be, my lord. If the absolute bar, my lord, then.
There is no reasoning in the division bench's order.
Supreme Court judgment is there.
That shows that.
Yes. That is yes. Paragraph 21. Paragraph 21. May I read, man? Now it is the discussion of the your lordship.
Now, what is the allegation against you?
Page 20, your lordship will find. My lord, they doubting the informant as which. They have page 20 as is the FIR. They have assaulted her.
Assaulted her and, my lord. but the
And,
person forced
and
her.
one person, namely Rajiv Madhok, he is not before your lordship. As per the allegation, my lord, that particular person forced her to eat stool. But Rajiv Madhok is not before your lordship. So for assault part is concerned, it is there. This allegation is against before all the papers and four petitioners.
Is your name?
We are, my lord,
Jyotish.
yes, 4 person, my lord. Jyotish Madhok, Manoj Madhok, Bulbuli Madhok, and Minabati Madhok. 2 ladies and 2 gents. They are from same family. The worst part, that is against Rajiv Mehta. And investigation is completed, it is all matter, my lord, almost 8 months is going to be over. Man. We will cooperate, we will continue.
Which section is there?
Section 9, man. Section 9(2). Punishment is 5 years and may extend it to 10 years. Page 27, I have annexed the act, man. Uh,
9(2).
9(2).
Where is the FIR?
FIR page 20, it starts.
9.
Page 27, relevant person, it starts from 25, act I have annexed. 9(2), minimum punishment not less than 5 years and may extend it to 10 years. Investigation is completed, my lord.
All right, any submission from prosecution?
There, but they all have been searched there, madam. They were shown as an absconder in the search sheet, madam. So only, madam, the question is that whether, madam, they can be protected or not, madam, since that there is a bar, madam, under the Authorised Act.
That is the import of the judgment of the apex court. In suitable cases under writ jurisdiction also, it may be necessary to interfere. Depends on what is the material against the. So same principles basically will apply for 438 in an indirect way.
But, madam, the
My lord
allegation
is well over
is
it.
otherwise serious, madam. Or is inhuman, madam.
It is available here.
Yes,
Yeah, that's it. Okay. Because
Because the record it is there.
Hmm?
It has been forwarded.
that's it, Asana Sili.
Hard learned counsel for the and learned additional PP. Article 226 of the Constitution. In respect of offenses, protection from arrest in respect of offenses under sections 351 within bracket 329 BNS, read with section 9 within bracket Roman 2 of the Assam witch hunting within bracket Prohibition Prevention Act 2000. Para two of section 30 Act, there is a bar front of in respect of the aforesaid Act. Section BNS or
Now for 482 equivalent, yeah, 430.
is BNS will be applicable.
No,
For it.
482.
The Honorable Court in Misra versus the State of Uttar Pradesh and others, 2014, 4 SCC 453 as follows. Para 21 at 6 is judgment. Therefore, the of the instant repetition is question. Actually, the matter had come up before a division bench of this court, and in view of opinion expressed by the division bench that matter should be placed before a single judge of the court, placed before the Honorable Chief Justice. Accordingly, view of orders passed, this matter has been placed before the bench. Para. Regard to the facts of the fire was lodged by the informant in Gilamara Police Station, case number 33 of 2025, to the effect that on 16/9/25 at about 7 a.m. the accused, one of the accused persons, went to the house of the informant and asked her to go to the house of one of the petitioners herein, namely Minabuti Medak, for an important discussion. And upon going there, all the accused persons named in the FIR started mentally torturing her by branding her as a witch and one of the named accused persons, Rajiv Medak, forced the informant to consume human excreta. Para. Accordingly, the present case has been registered under the aforesaid sections of law. The investigation of the case is over and the IO has submitted the charge sheet by showing the present petitioners as absconders. Learned counsel for the petitioner submits that the petitioner shall duly cooperate with the trial and that at this stage not be necessary to place the petitioners under custody. Learned additional PP submits that the petitioners may be directed to appear before the learned trial court.
That may not be mentioned, my lord.
Not necessary.
Mentioned, my lord, because it is such that case, my lord. And trial court has issued summon to them, my lord.
Pursuant to summons.
Pursuant to summon, my lord, then let them, that may not be.
That can be your submission that since summons have been issued, they should go and appear.
Yeah, they should go and appear.
That is what we have said.
The protection, but I'm not submitting, my lord, they should be protected, my lord.
No, that is not what we are saying. We are saying that learned additional PP submits that since summons has been issued in the case, the petitioner may be directed to appear before the learned trial court.
Yes, ma'am.
Having regard to the allegations made in the FIR, as well as the contents of the charge sheet which I have perused, it appears that the principal allegation against the present petitioners, as per the charge sheet, is that they committed obscene acts and uttered obscene and abusive words public place against the informant. But the more serious allegation of forcing the informant to consume human excreta is against one Rajiv Medak, who is not before this court in the instant petition. Having regard to the above, as well as the fact that the investigation is complete, and as well as to the nature of the allegations against the present petitioners, I am of the view that it not be necessary to take the petitioners into custody at this stage. Also, accordingly, it is appearance of the petitioners pursuant to summons issued by the learned trial court. They shall be released on bail on such terms and conditions as thought fit to be imposed by the learned trial court. The writ petition stands disposed of accordingly.
Apply.
Send back the records.
I appeal your lordship.
Yes.
This revision is directed against the Milord criminal proceeding against the
Senior counsel appointed in the
Heard learned counsel for the petitioner. The prayer of learned counsel for respondent number 2. Stating that Sir D. Ullah, learned amicus curiae, is not present today. Directed that the matter be listed again on
after family up to 20 April.
I'm obliged to that.
Please, your lordship. Jail.
heard learned counsel for the appellant, learned additional PP, as well as learned amicus representing the informant. This appeal is directed against the so and so. My appeal is admitted. Call for the TCR. The matter again on.
No, Your Lordship. The TCR has already been received, you know. The
Lordship, I'm for the informant. Basically, here in this case, we'll be filing an objection because of this particular notice was served in between last order. So it's been engaged, and now we are going to file an objection because in this particular matter, that particular ingredients are there, which
All
directly.
right, heard learned counsel for the petitioner and learned additional PP TCR is called for has been received. Learned counsel has also entered appearance for respondent number 2, and it is submitted that an objection will be filed. Accordingly, list the matter again on. So and so in the meantime, objection to be filed by respondent number 2.
Apply. Apply.
Yes, Judge. Last order in the. Yes, where is the evidence?
It is in the up-to-date status report, the very first page of the scan copy of the record, my lord. It has been examined, my lord. She turned hostile, my lord.
Yes, PP.
Examine PW1, my lord. Lordship, first, my lord, gone through the, my lord, our evidence, my lord. See, that hostile, my lord. And that's why, my lord, prosecution process examine hard, my lord. And first put, my lord, all the question, my lord. Let's hear before the investigating officer.
Hmm.
Our evidence, my lord, it is clear, my lord. But trial also, my lord.
Learned counsel for the petitioner and learned additional PP. Any submissions?
Own brother-in-law of the victim, my lord. So
Hmm?
brother-in-law, my lord.
To do CS anyway. This is an application under so and so. The allegation against the accused petitioner is that he repeatedly committed penetrative sexual assault upon the alleged victim aged about 16 years, who is also the sister-in-law of the accused petitioner. The accused was arrested on
10/8/2025.
25, and in the meantime, upon completion of investigation, the charge sheet has been submitted, and course of trial, the victim has already been examined. Certified copy of the deposition of the victim has been placed before the court, wherefrom it appears that the said victim has not supported the prosecution case. Having regard to the above, as well as the period of detention undergone, the prayer for bail is allowed. The accused so and so shall be released on bail of 50,000 with one surety of like amount. With the satisfaction of the learned trial court, it is further provided that the petitioner shall cooperate with the trial and shall not default in appearance. Petition stands allowed accordingly.
Yeah, please.
Please, lordship. It's certified with your lordship. And deposition of victim and witness has already been taken, lordship. And as on that, lordship, 174 days behind the bar, lordship. Also is there. Right. I have obtained a certificate copy of victim's statement, lordship. And in the statement recorded under 183 of lordship, there is some contradiction, lordship. The witness statement.
But trial has commenced.
Going on, lordship.
Victim examined.
Yes, lordship.
Is it available here?
Statement is only
before the court.
Statement is recorded before the SDJM, lordship.
We're not asking about that.
The evidence part is not going on, Lordship. That is fixed, Lordship. That part is not there, Lordship. Affair is totally concocted, Lordship. I have already explained. There is a quarrel between the victim's boyfriend and the petitioner, Lordship. While he was entering in the house of the victims to bring one plow, Lordship, he restrained the petitioner to enter the house of the victim, Lordship. That's why a quarrel was. Page 33, Lordship, statement of the witness grandmother, Lordship. He stated that he বিছনাৰ চলাই সি মোৰ নাতিনী গায়ত্ৰীৰ লগত কাজিয়া কৰে. But in the police statement, Lordship, he stated that মই ৰুবুল নামৰ ল'ৰাটো in 31, page 31, ৰুবুল টাও নামৰ ল'ৰাটো ঘটনাটো হোৱাৰ দুদিনৰ আগত আমাৰ ঘৰলৈ নাঙলখন ল'বলৈ আহিছিল. Bail application, my lord. At this stage, my lordship would not. Let's call the contradiction, my lord, before the 161 statement.
I'm trying to understand what is the actual accusation.
This one is that, my lord, he touches her, my lord, chest and stomach, my lord. Tried to pull her out from the house, my lord, from room. But he protested, my lord. He assaulted with his mobile phone, my lord. That is
Trying to
totally
see,
absurd,
find
Lordship.
out whether the trial has commenced.
He has produced one evidence.
Oh, that is 183 statement only.
Trial is at the stage of preparation of charge, Lordship.
That is
From
what I-
online, I have
Charges yet to frame, my lord.
no PDF examined.
Where are you saying trial has commenced?
183. The victim examined, my lord. After that, my lord, his bail application may be considered. Already 174 is behind the bar, Lordship. And fact is totally concocted, Lordship. It is established from statement recorded under 181 and 180 and 183, Lordship. Grandmother says something different and victim says something different. The grandmother says that when he put on the flashlight of the mobile phone, he identified the petitioner, accused petitioner, Lordship. And victim says that while he strike on her head through his mobile phone, the flashlight of the mobile phone is put on, then he identified. And in the affair, he says, he comes and whisperingly petitioner says that I am rebel, don't cry. Considering that it's like Lordship, I maybe go on bail, Lordship. I will appear before the trial as directed by your Lordship.
Yes, respondent 2.
Not examined as. And there are a number of witnesses in the charge sheet. Is that advantage of loneliness of the grandmother and the victim? The accused entered the room first and tried to commit Last occasion, he was directed to produce the certified copy of the statement of the victim.
I have certainly.
That was as.
183 is anyway available.
Yes, Lordship.
Any date fixed for charge?
Date is 29/4. From online, it could not be whether charge was framed on 23. Next date is for 31/3 for production of accused and CC. Then hearing on 31/3, Lordship, fresh issue summoned to the PWs. OPW is present, fixing 29/4/2026 for evidence, issue summoned to the PWs. 7/4 again he was produced and the same order issue summoned to the PWs fixing 29/4. Charge order is not online. Accused and victim from the same place, Lordship.
The victim girl has some love affairs with other person, and he at the instruction of the boyfriend Lordship, he has filed this affair, lost the affair. Now, he was entered to their house to brought that law
They
only.
have submitted charge sheet under 64 also. Then why not section 4 POCSO?
Section POCSO is 8 and here rape.
That discloses the mindlessness of the IO.
Already behind bar for 6.
Third learned counsel for the third learned. You are amicus. Allegation against the petitioner is that he entered into the house of the him who is a minor while she was sleeping with grandmother and touched her body and attempted to drag her out. There are the location of the case. Or within bracket 160, 74, 75 to ENS read with section 8 of the POCSO Act. pertinent to note that the into the IO rape has been made out the basis of the aforesaid allegations. Presumably, that is the reason why section 64(1) BNS finds mention in the chart. But at the same time, despite the victim being a minor, since under section 4 of the POCSO Act is made out against the petitioner according to the IO. Para. In regard to the fact has been behind bars for how many days?
174 days, Lordship.
174 days, and the nature of the allegations. Therefore, bail is will be released 50,000.
Obliged, Lordship.
Debate in the trial.
Much obliged.
Lordship, in this case, the petitioner is behind the bars from since my lord 6/10/2025, my lord. Last occasion, my lord, initially DNA test report was called for, my lord. And subsequently on last occasion, my lord, time was sought by the status of the case, my lord. My lord, FIR at page number.
DNA report was to come.
Mine.
No, my lord, we have already communicated with the IO, my lord, but the same is not available, my lord, at that point of time, my lord, and he was also busy in election duty, my lord. Now, my lord, I have gone through the scan copy of the record, my lord. On 27/3/2026, charges have already been framed, my lord. Now, my lord, the matter has been fixed on 10/4/2026 for evidence, my lord. Now, my lord, the DNA report, my lord, that will be, my lord, subject matter of the trial court, my lord. Whether the DNA report is matched with the, my lord, trial or not, my lord. My lord, it is calling for the report, my lord, in this court, my lord, for the purpose of bail, my lord. Let him, my lord, I'll be appropriate application, my lord, because the matter has already been searched, my lord.
After
The victim examined, my lord, it can be confronted
No,
with
my
the
lord,
victim, my lord.
after submission, filing of the part charge sheet, my lord, my bail petition.
This
was
is not
taken
part
by
charge
trial.
sheet, my lord. Charge sheet has been submitted, my lord.
No.
But at that point of time, when the charge sheet was submitted, my lord, the DNA report was not available, my lord.
Now, whether it is available.
It is, my lord, when we inquired from the IO, my lord, he said, my lord, due to, my lord, busy in election duty, my lord, he's not been able to, my lord, collect the DNA report, my lord.
My lord, going by the allegation made in the FIR, my lord, on last occasion, the court, it did find it required that the DNA test. Only thing is that, my lord, if DNA test report is used before the court, my lord, that even if it is comes positive, then my lord, a question of bail may not recognize, my lord. My lord, FIR, lordship would see that, my lord, fake statement has been made, my lord, there is no specific day. And the allegation is made that he took broad daylight, my lord, in the marketplace, my lord, page 9, 14, my.
Since report has been called for,
Sometime may be granted, my lord.
already DNA report is called for has not been.
Immediately on reopening, my lord. Immediately on reopening, my lord. Considering,
Okay, my lord.
now, my lord, considering.
Today is the last day, my lord, then it will be the next opening day is the 20, my lord. We have to, my lord, inform the IO, my lord.
My lord, last two occasions, my lord, initially, my lord, DNA test, subsequently time was.
If we direct it to be listed immediately after reopening and DNA report is not available, then we'll decide on merit.
My lord.
Agreed.
the ends of justice, my lord, the court has, my lord, sought for the DNA test, my lord. Finding upon petitioner as well as the petitioner learned additional.
Are you answering my question or not?
My lord, if the, my lord, the thing is, the court has sought for the DNA test report, my.
And you are insisting on a date. That is why we are saying.
My lord, considering, my lord, length of detention, my lord.
All right.
It's Sarchited case, my lord.
Is the matter on so and so? In the event that the DNA report is not received on that date, the matter will be decided on merit without the DNA report.
My lord, that may harm me, my.
We pass the order.
Let it be posted as
No.
per courts.
You are wasting the time of the court, and that is the
No,
result.
due respect,
Yes,
my
next
lord.
item.
My lord, court call for the DNA test report, my lord. If additional if we fail to produce the before the court, my
You
lord.
keep insisting, we'll pass even more adverse orders.
May I please tell us? My lord, I have filed an additional affidavit, my lord. Kindly have a look, my lord, my addition. It's on record, my lord.
What is to be done?
It is, my lord, section 36 of BNSS is not followed, my lord. It's a mandatory provision, my lord. Because I would like to place.
Now, who is to file additional affidavit? Huh?
I have filed, my lord.
You have filed,
Yes.
they have to file objection.
They have to file objection, but they did not file, my lord.
Is violation of?
Section 36, my lord, BNSS.
Where is 36 notice?
My lord, I have page 48, my lord. I have written it.
You have examined the record?
My lord, yes, one thing is that, my lord, they have, the grounds of, yes, the grounds of that section 47, 48 also not followed. It is in English, but the petitioner himself signed in English, my lord. That
No,
is
no,
there.
he is on 36. Let us
36.
take care of 36.
Yeah. 36, my lord, that signature of the accused is not found. I have not seen.
Signature and witness both have been absent.
Page.
Page 48, my lord.
So you have filed additional affidavit.
Yes, my lord. Page 47 to 49.
Where is that notice?
Notice
Not
here,
notice, it is a arrest memo, my lord. It is on record, my lord. I have flag marked it. This is a red color flag mark, madam.
Yeah, that first.
Red color flag mark, madam. No signature of the accused, no signature of the witness.
Yes, any further submission?
But regarding that, my lord, otherwise commercial country, but that 36 notice, my lord, section. Yes, sir, this is not there.
Third learned counsel for the petitioner and learned additional PP. This is an application under so and so. Recent case is that paragraph 2. Petitioner was arrested on 15/5/25 and since then he has been in custody. Trial is going on
Yes, madam.
Trial is going.
Go ahead.
and the trial of the case is underway. Who's learned counsel for the petitioner submits that there has been a violation of section 36 BNSS in as much as neither the signature of the arrestee nor that of any witness as mandated by section 36 BNSS is available in the arrest memo. So a perusal of the arrest memo confirms the aforesaid submission of the learned counsel of the for the petitioner. Arrest memo which is available in the record. Learned additional PP fairly admits that such signature as required by law is available in the arrest memo. Further, section 62 BNSS provides as follows. Section 62 কোড করে দিব। তার আগত দিব section 36 BNSS provides as follows to কোড করে দিব। Additional affidavit page 40. 48 or DI আছে 36. View of the above titled released on bail accordingly. It is directed that the petitioner so and so released on bail of is 50,000 with 2 sureties of like amount, one of whom must be a regular government servant. Satisfaction of the learned trial court. It is further provided that the petitioner shall regularly participate in the trial and shall not try to influence the witnesses in any manner. Petition stands disposed of accordingly.
Please, Your Lordship, actually, here the state was made a party. Currently, the matter has been transferred to the NIA last month. NIA is not implicated as a party as yet. Elected. first they'll have to file a memo of corrected parties. And secondly, Lordship, perhaps they should approach the trial court first, because court will entertain only an appeal.
So it was rejected by trial court.
They have come for the.
Yes, Lordship. Directly High Court Lordship. Before, because before the NI was not involved.
So what survives?
I may be allowed to amend the petition Lordship.
Even if you amend it,
Lordship.
They have explained it to him.
even if you amend it, it will still not be maintainable. You have to approach the trial court first.
I may be allowed to withdraw Lordship.
Prayer of learned counsel for the petitioner. The matter is dismissed as withdrawn. Liberty to the petitioner to approach the learned trial court as per law.
All right.
8, 9, 10. Lordship.
8, 9, 10. All right.
May it please, Your Lord.
11, 12 and 13, my lord, arising out of the same affair, my lord.
May it please, Your Lord. It's a regular bail, my lord. Lordship, may kindly have a look at page 20, my lord, because the FIR is very long, my lord. Page 20, the forwarding report, my lord. Lordship will see, my lord, the 3 persons, my lord. Shahil Ahmed, my lord, that is item number 11. Rakibul Islam, item number 12, and Saddam Dewan, 13, my lord. A brief history of the case, my lord. May I read, my lord?
Yes.
Brief of the case is that on 19/2/26 at about 10 p.m. information was received at Dolakal outpost that one person had been detained by the local public in front of SBI ATM at Rampur, which allegedly attempting ATM card fraud. It was further reported that the person was in possession of a multiple ATM cards and suspected heroin. The information was entered by GDE number so and so. An authorization under section so and so of the NDPS Act was obtained for search and seizure of them. The police team proceeded to the spot and found the accused, namely Shahil Ahmed of so and so, detained by the locals. In presence of the independent witness and in compliance with section 50 of the NDPS Act and relevant provisions of the BNSS, a search was conducted. During search, 3 plastic vials containing suspected heroin weighing 3.92 grams. 33 ATM cards of various banks, rupees 2,000 in cash, 1 money purse and 1 polythene bag were recovered and seized while MR number so and so. During preliminary interrogation, the accused disclosed the involvement of 2 associates, namely Saddam Dewan and Rakibul Islam, who managed to flee away from the spot. Subsequently, they were arrested. My case is, my lord, today it is, my lord, 49 days, my lord. And my lord, the investigation period is, my lord, of 60 days. And moreover, I have done nothing, my lord. From the only suspected, my lord.
What about this some recovery of heroin?
Heroin, my lord, that is, my lord, a small
quantity.
Small quantity, my lord. And so far, my lord, one more thing, my lord, the search of a person, my lord, that should be done before a magistrate or a, my lord, not before any police, my lord. I have done
What
nothing.
offense is disclosed by this ATM card? Any report on whom these ATM cards belonged or anything?
Yes, my lord, that two person statement, 183 statement have been recorded, my lord, 2 persons, my lord. What happened, my lord? On 5/2/2026, before this person was arrested, my lord, information already lost, my lord, by this victim, my lord, that their ATM card was exchanged, my lord. Thereafter, my lord, around 67,000 and around 70,000 rupees was, my lord, fraudulently withdrawn, my lord. Thereafter, my lord, on 19, my lord, this accused person was my lord, caught by the public, my lord, in the ATM booth, my lord, while he was trying to, my lord, commit the same offense, my lord, with other victim, my lord. Then he was caught by the public, my lord. Police was informed. Then police came, my lord. When his body was searched, my lord, the contraband also recovered, my lord, along with 33 numbers of ATM card, my lord. And on the basis of his statement,
How does he obtain the ATM cards? How the 33 ATM cards are obtained by him?
No, that ATM cards are, my lord, they collect, my lord, some of those ATM cards are not genuine, my lord. What they does, my lord, they exchange the ATM card with the customer, my lord. After withdrawing the money by the customer, my lord, they somehow, my lord, doing some tricks, my lord, they exchange the ATM card, my lord, and customer was given the ATM card, my lord, possessed by them, my lord. Then they will fraudulently withdraw money, my lord. When the customer came to know, my lord, then, my lord, they informed in the police station, my lord. This is the allegation, my lord.
Yes,
The other case which has referred, my lord, that is, my lord, Mukalmua PS case number 21, my lord, I got bail, my lord. 49 days, my lord. Yes,
investigation is still pending, my lord. Yes.
but I have done nothing, my lord. So far, this forwarding report says, my lord. And the other 2%, my lord, on the statement of this Sahil Ahmed, they were arrested. Length of detention, my lordship, considerable. No.
So there are three CDs.
No, same.
No, my lord.
One CD. What about, okay, three
We are only
petitioners.
concerned about the Mukalma PS case number 21, my lord. In whose connection, my lord, these petitioners were arrested, my lord.
3% same FIR, my lord.
What is the stage of the investigation now?
Case is pending for further investigation, my lord, and my lord, the contraband which was recovered and seized from the, my lord, Sahil Ahmed, my lord, it was sent for FSL and it tested positive, my lord.
Small quantity.
But they're no longer required for interrogation, is it?
That, my lord, as per the city, my lord, it is pending for further investigation, my lord, because
Further
there will be some other
investigation may mean anything, but
because, my lord, the person, my lord, who are the victim, my lord, they initially, my lord, could not, but later on, my lord, they have identified this person, my lord, when they were after their arrest, my lord.
just pass over the CD for.
Yeah, look at it.
It had learned counsel for the petitioner. For the, this is an application under so and so. Paragraph 3, facts of the case. Where was the forwarding report page?
Page 2201. my lord.
Paragraph 3 na lage, page 19, brief history of the case. I couldn't read it. Learned counsel for the petitioner submits that the quantity of heroin recovered comes in the category of small quantity. Furthermore, regard to the other alleged offenses, submitted that considering the period of detention of 48 days,
49 days.
49 days, and in view of the ensuing vacations, prayer for bail may be considered. An additional PP submits that the petitioner has been involved in fraudulently obtaining ATM cards by tricking the victims and thereafter using the same to withdraw money from ATM, from the ATMs. The CD as called for has been received and perused. Considering the material available, and also the period of detention undergone so far, here's that further detention of the petitioner be necessary. Therefore, bail is 1,000 is learn it.
CGM Nalbari.
Further provided that the petitioner shall cooperate with the litigation and shall not try to tamper with the evidence. Cancel out accordingly. 11, 12, 13, same order.
I'm obliged, my lord.
Same back.
Your lordship, my lord, regular bail application arrested on 6/3/25, charge sheet filed on 30/4/2025. My lord, the trial court record has come. My only argument, my lord, is this. My lord, your lordship I have track marked the trial court record. Your lordship may look into the 47 and 48 notice.
There is nothing, my lord. In 48, nothing is there. And in 47, only reasons for arrest is there. And I have taken that ground specifically, my lord. And my lord, I will rely upon this recent revision bench judgment of our court, along with Probit Pulokasto, para 38. Your lordship may look into, I have flag marked. They have given the reasons, but nothing. In 48 notice, nothing is there, my lord.
My lord, in 47, my lord, ground number 2.
That is not ground, my lord. Again, my lord, the submission has to be, there is a reason. Because only by placing the wrong statement will not do, my lord. Because that is not ground, that is reasons. What is ground? That is AR 56 Allahabad, page 56, which has been relied upon in Reddy versus NCB in 23 May 2025, where it has stated that what is grounds of arrest. Grounds of arrest for which I will come to know, for which I am being placed for trial. That has been laid down in AR 56 Allahabad.
Where is the FIR?
FIR, my lord, is at page 13. This Probit Pro customer I'm handing over, para 38. What is reasons for arrest is different, man. And grounds of arrest is different.
So allegation is of direct recovery from him.
Bedroom, my lord. 17,520 capsules recovered from bedroom. My lord, kindly peruse the grounds number 2. Others, my lord, may be reasons. If not arrested, then he will, that may be reason. But ground number 2, my lord.
That is definitely a ground,
My
not
lord,
a reason.
my lord, I am specifically stated that, my lord, that 2.
Yes, now 48.
48 details are not given. That is dear, my lord. 47, he know from his bedroom, my lord, 17,520 capsules, my lord, seized.
Where is 48?
48 in para page,
Next
20,
next,
my lord.
next page, my lord.
Next page.
47, next page of 47, my lord. Petitioner house was searched, my lord, in house is found.
So nothing is there, not even a whisper.
In 48, my lord, you can 14 kg 600 gram of capsules.
And this is,
But one thing
this is
that
post Vihan Kumar.
post Bengal. But one thing is that Malat, yes, in his house, it is search, all the family members in house is given. That
You can submit that for your satisfaction, but law is known to you as very well.
but my learned friends stated 48. I am going, madam. No, 47. No ground is not understandable. There is ground, Malat. Specifically, B is the ground.
Not clean board, but LBW. Had Mr. Roy Chaudhary, learned counsel for the learned edition of FDP. This is an application under section.
Sir, I'm sorry, can I, my lord? I have to go for the vote. Sorry, my lord, I'm late.
The allegation against that upon receipt of secret information, a search was conducted in the house of the petitioner, and the total quantity of 17520 numbers of Samplex plus capsules suspected to be psychotropic substance was recovered from his bedroom and was arrested. Thereafter forwarded on 06/03/25 was remanded to 5 days police custody, whereafter he was remanded to judicial custody, and since then he has been behind bars. The learned counsel for the petitioner has urged that 48 of the NSS has been violated, inasmuch grounds of arrest has been mentioned in the notice issued thereunder. The result of the aforesaid notice per section 48 BNSS. I find force in the submission of counsel the petitioner, as much as no ground of arrest has been shown therein. Fact to which the learned additional PP has also fairly pleaded. Therefore, in view of the decision rendered in Vihan Kumar versus State of Haryana, so and so, the arrest of the petitioner been rendered illegal, entitling him to released on bail. Therefore, bail is on bail of 1 lakh securities of like amount, one of them being a regular government servant. Satisfaction of the learned trial court. I did that the regularly appear before the learned trial court and shall not try to influence the witnesses in any proceed.
Operators.
Second bail application, Lordship. Earlier bail application was rejected on 19/11/2025. That your lordship will find page 53. And as on today, lordship, he is in custody for 1 year, 7 days, lordship. 1 year, 7 days.
Here was called for, it has not been received. As per office note dated 12/3/26.
TCR in connection with disposal of matter is their lordship wanted to only know that whether the appearance is complete or not, because my on last occasion I submitted with your lordship that although in the rejection order your lordship has observed that case is lordship charge sheeted and committed, page 54. Page 54, lordship. At serial number 5, but the case is still in appearance stage, lordship.
The latest report will be called. Latest status report will be called for records that are before your last year, lordship, if I'm not. It pertains to the previous disposed of case. In this case, the fresh TCR was called for, which has not been received.
Learned counsel for the petitioner. LPP. For office note, the scanned copy of the TCR has not been received. To issue reminder, also call for a status report from the learned CSM from Rupmet.
Lordship, I fixed it. Immediately after vacation, I will also obtain, try to obtain that certified copy of last orders, lordship.
Is the matter again on?
Obliged.
The CD has not been received.
But my lord, today is lordship, second time, yes, lordship, and I am allowed behind the bar, your lordship, already 83 days, my lordship.
Yes, lordship, the service upon respondent number 2 is also not complete.
My service has been completed, your lordship, as per last order. So my
Last order is await service report. It had learned counsel for petitioner. Learned additional PP. Service on respondent number 2 is not yet complete. And CD is also not received. Hence await service report. This is the matter again on.
But my lord, today is 83 days, your lordship. The investigation period is 90 days, my lord. So 6 is there, your lordship, but my lord, she is above 17 years old, your lordship. The actual fact of the case is that, your lordship.
If statutory period is over, you can apply to the trial court also.
For them to withdraw it and approach the trial.
Then my lord, I may be allowed to withdraw, your lordship.
Withdraw. The prayer of learned counsel. The matter is dismissed as withdrawn with liberty to approach the learned trial court. Yes. Accordingly.
Master, please.
Please, lordship. Regular bail application manner. Micas was appointed earlier, man. We had taken steps. Melody Ajahar, you lordship will find that. Page 10. My lord, I was arrested on 9th of July, 2025. About 9 months. And the victim and the informant have been examined. I think the records are there. Man. My lord, two things, my lord, at page 10 in annexure, in a Ajahar, your lordship will kindly see the line, Riyashri has not named the accused and is changing her statement repeatedly.
How were you arrested?
My lord, then my forwarding is there, my lord. Page 18, 17, 18, my lord. The grounds of arrest, they are the arrested accused persons is the FIR named accused, my lord. In fact, no name was given, man. And the victim is, my lord, turning 18 on 11th of this month, my lord. 11th April. My humble submission is at best, my lord, except for the age, my lord, it was a consensual.
Like not the evidence of the
Hmm?
PW1 is the victim evidence. Let's say her date of birth is 11/4/2009. So she was around years of age and pregnant. Clearly implicated the present.
26 of February. 26. 23.
One last submission.
Information is there.
Altogether, there are 8 PWs, Lordship, who have already been examined. And the other witnesses, Lordship, they are all the relatives of the victim and the accused himself. The accused being the maternal uncle of the victim, Lordship. A question of consent. So at this stage, Lordship, the next date was fixed on 2nd of this month, Lordship, for evidence. At least
9 months, my lord, he is behind bars.
let the witnesses be examined, Lordship, at least the family members.
He will be with her mother, man.
Sir, the gravity of the offense is such that normally we don't grant bail in such cases unless we find something highly contradictory. Here is squarely implicated. Even during cross, he stated
Yes.
the first time was forceful. Even if your consensus was to be believed, then it is, but only subsequently. Here, first time, even in cross, he said that it was forced.
Participate in the question of consent also doesn't come as well as the family member.
He is the only man to look after his elderly old mother. Only person in the.
Oh, you say he's behind for 8 months, so by now they must have managed.
Well, they will manage, people will manage, people have been managing, in difficult situations, but that is another thing, but they are having some.
And had it been other, yes, you're the maternal uncle, you are partly a guardian of the girl.
Well, I understand that.
It heard Mr. Swenson learned counsel for that. And additional PP also heard Ms. So-and-so, learned amicus representing respondent number 2. This is an application under so-and-so. The brief facts of the case are that the victim, girl aged about 16 years, had gone to stay in the house of her grandmother, wherein her maternal uncle, that is the present petitioner, also resided, and taking advantage of the absence of her grandmother, huh? Is it stated the grandmother?
Yes, yes.
Absence of grandmother, the accused person forcefully committed sexual intercourse with the petitioner and continued to do so even thereafter. On conclusion of investigation, the charge sheet was submitted and the trial has also commenced, wherein the deposition of the victim has already been recorded. Upon perusal of the said deposition of victim before the court, I am of the view that this is not a fit case for grant of bail, particularly having regard to the gravity of the offense and the nature of the relationship between the victim and the accused petitioner. Accordingly, the prayer for bail can be rejected at this stage. At this stage, yes.
That's all.
My lord, the petitioner arrested on 6/3/2026, 33 days today. Now, on the offense is that, so on the basis of statement of Quick, which was arrested, I have been arrested. The loss of the FIR is page 11. Nothing against me, my lord, but one person who was arrested, he disclosed my name. So the city was called for received, and last occasions my friend was asked to make a submission that whether the parties are live or dead. That
I for dead.
Yes.
FSL report, my lord, of the arms, my lord. FSL report, if received, my lord, the arms is serviceable, my lord, and the cartridge recovered, my lord, it is also live cartridge, my lord.
That
They
is
possess the, my lord, arms, my lord, without any valid license, my lord.
It is
So
not
this is not
possible.
a case, my lord, to grant his bail at this stage, my lord.
My lord, it is not recovered from my positions, my lord. It is recovered from one Krishna Das. Was arrested in his positions, all the things has been arrested, recovered. So, my lord, the 33 days, I will provide for the investigation. Any condition, my lord, I may be allowed to go on bail. My statement has also been recorded, my lord.
Only because of his statement, I have been arrested.
Anything else other than statement of co-accused?
My lord, he himself stated, my lord, I gave the, my lord, pistol to my lord Krishna Das, my lord.
That is his
Arms is
statement.
recovered from Krishna Das, my
It
lord.
is
Then when it was asked, my lord, he has
under
stated that
threat.
he bought the arms and the ammunition from Akhilesh Thakur, my lord.
That is what,
Without
that is
any-
the
my
statement
lord,
of
even Akhilesh
co-accused.
Thakur also could not produce any license, my lord.
Correct.
So whether, my lord,
No, why should
it
he
will come
produce
under
license?
the, my lord, Arms Act or not, my lord. This is my humble submission, my lord. Without any, my lord, valid license, my lord, how can they, my lord, carry and possess?
That
my
is
lord,
why I am
ammunition?
arrested. That is I am
That is the
arrested. I have been
investigation complete, my lord.
This is an application under so and so. For the FIR, a 9mm pistol along with ammunition was recovered from the possession of one Krishna Das on 05326. He was arrested and during arrested and he could not provide any valid license or legal documents justifying his possession of the aforesaid arms and ammunition. And upon his interrogation, it was revealed that he had bought the said articles from the present petitioner. Learned counsel for the petitioner submits that nothing was recovered from the present petitioner and he has been implicated, arrested only on the basis of the statement of the co-accused. The other hand, learned PP, so it is Sinner himself has admitted that he had told the said
Soul, my lord, given, my lord.
Given
the arms to
given the
one,
arms
my lord, Krishna Das, my lord. And he also does not possess any, my lord, license.
co-accused Krishna Das, and he also could not produce any license or legal document to account for the said arms and ammunition.
And my lord, he has, my lord, procured from Bihar, my lord.
Since the
My statement is on threat, I make such a statement.
He has
that
brought the
the
pistol from Bihar, my lord.
said present petitioner is although he present as per the FIR, he presently resides at Gauhati, Gauhati. Para the Honorable Apex Court. So and so. Statement of the co-accused taken into consideration for the purpose of deciding the bail application. The material indicating the is discernible from the PD. In view of the social release 3,000 with securities being a government servant. The satisfaction of the is in Kamrup.
Metro.
Provided that the petitioner
Metro.
shall not leave the jurisdiction of the Internet CSM Kamrup without prior permission.
High level.
Meet me, Your Lordship. Your Lordship,
433 application, my, and my lord, the petitioner is behind the bar for 77 days, my lord. Lord, FIR is at page number 16, my lord.
Well, before my answer start, my lord, this is a UAPA Act, my lord, and here, my lord, rejection order is at page 32, rejected by the special judge Nagaon. So, my lord, here, my lord, BA is not maintainable, my lord, it has to be before division bench, my lord.
In that regard, my lord, I want to make a submission, my lord.
As per the, my lord, judgment.
My lord,
Where is the rejection order?
Page 32.
Page 32, my lord. My lord, the judgment which friend is submitting, that relates to a case where charge sheet has been laid down, my lord. Now, under that bar, there the section 21 of NIA Act has been discussed where there is a bar. But my lord, under NIA Act, my lord, this is a special act. Section 16 lays down the procedure and powers of special court, my lord. Section 16, my lord, may I read? A special court may take cognizance of any offense without the accused being committed to it for trial upon receiving a complaint of facts that constitute such offense or upon a police report of such facts. Now, my lord, now this special act comes into play, my lord, when a charge sheet is laid down or a police report is filed. And after that, if any order is made regarding refusal or my lord, granting of bail, then my lord, an appeal will lie, my lord, to the division bench, because the case which is citing their charge sheet has been laid. And my lord, I'd like to read out section 43D of this UPA Act, my lord, because after enacting this NIA Act, a modification was made in UPA Act, my lord, where the applicability of certain sections of CRPC or now BNSS, they were excluded. Under 43D, my lord, subsection 4, not there on in during this modification, my lord, only the provision relating to anticipatory bail, my lord, section 438, applicability of that section was only excluded, my lord, but not applicability of 439, my lord. So now, though, my lord, this
UAP Act. Lawful activities. This PP under this is not an investigated case.
No.
Under what provision it is to go before the division bench?
My lord, in coordinate bench judgment, my lord, one is that may kindly period section 22
of this is not NIA.
but he is doing other cases, my friend will.
The designated court, session court is designated as the special as per section 22.
Because these are scheduled offenses.
Yes. Section 22 of the NIA Clothville that
Read out.
oh yes,
Read it out.
power of the state government to designate court of session as special courts. Different courts trying these offences, Lordship, special courts, and there is a notification to that has been also reflected in that order before your Lordship.
This is covered by earlier decisions.
My lord, that case is, my lord, a charge sheeted case. And there is no dispute that the session courts were designated as special court, my lord. But whether it is exercising that special court while dealing with
Where is the
case-
distinction between charge sheeted and non-charge sheeted?
Because my lord, this is a special act and it is silent about regarding filing of bail, my lord. And when a special act is silent, my lord, then
Silent.
no, it speaks about appeal against order.
Yes.
And
Lordship,
now
kindly-
this order, my lord,
Order covers bail order also.
my lord, whether
One Lordship,
after
kindly
taking
say-
cognizance or, my lord, because during investigation, my lord, tomorrow I may not be charge sheeted under UP Act, then this,
We have to go by what sections are applicable at this point of time.
21, if Lordship kindly pay.
because there is no bar in filing 483, my lord, bail under BNSS, my lord. It only says that if an refusal or grant of bail, my lord, then appeal would lie. Now, my lord, this order of bail, granting or refusal, because this session court's trial, my lord, this special court will come into play only after, my lord, filing of the charge sheet, because section 16 clearly speaks about its power. Yes. Till now, my lord, this charge sheet, neither charge sheet nor police report has been filed, my lord.
Just one section, Lordship will kindly take note of 21 of the NIA Act appeals.
Yes.
नहीं एकोनो लेटू नहीं होनो लेटू Yes, section 21 says
21 states Lordship appeals. Notwithstanding anything contained in the code, an appeal shall lie from any judgment, sentence or order, not being an interlocutory order of a special court to the High Court, both on facts and on law. Now, Lordship, what the subsection 2 says, every appeal under subsection 1 shall be heard by a bench of 2 judges of the High Court and shall, as far as possible, be disposed of within a period of 3 months. So this bail application, Lordship, has come up from a rejection order of the special judge, Lordship. I mean the session judge, who is acting as a special judge under section 22.
The designation of the court is special judge, my lord. But while dealing with this bail application, my lord, prior to filing of the charge sheet or police report, whether it was
section 21 makes no such distinction. Any order
by virtue of section 16,
does
my
not
lord.
say after filing of charge sheet. Section 16.
Yes, my lord.
Yes.
Because section 16 says a special court may take cognizance of any offense without the accused being committed to it for trial upon receiving a complaint of facts that constitute such offense or upon a police report of such facts.
So,
my lord, after filing of this only.
so that only concerns the power of the special court to take cognizance directly without being committed by a magistrate.
My lord,
That section is confined to that only. How does it?
then my lord, kindly 43 of this UPA Act, my lord. Because after enacting this act, my lord, certain modifications were made regarding non-applicability or excluding the certain provisions of CRPC or BNSF, my lord. There, specifically this 438, my lord, that is provision for anticipatory bail, it was excluded, my lord. Subsection 4 of 43D. But 439, it was not excluded. So 43D, modified application of certain provisions of the code, my lord. Subsection 4. So what provisions were excluded, my lord? These were modified here. 439, the applicability of 439, my lord, that was not excluded.
Having difficulty understanding how 43D is applicable to the question we are involved with.
Because after coming of this act, my lord, this is modified the applicability of
yes. That is with
because
regard
this
to
is also not clear, my lord, because here only
this relates
appeal
to
from an order was, but there is no specific bar, my
says
lord.
that every offense will be a cognizable offense.
My lord.
Firstly, then it increases the period of detention. Secondly, then where does it speak anything about
My lord,
where the
subsection,
bail bail application will lie?
but it is not.
It outs
Outside
438.
38, my lord, yes. So, my lord, if 439 would not be applicable, it would also have been.
Cannot be taken like.
When there is a specific provision covering how bail is to be dealt with. Only because of subsection 4, you cannot say 439 is applicable because 22 of NI, 21 of NI Act has ousted this jurisdiction by necessary implication. Okay, we'll pass orders.
Orders of the coordinate bench.
Yes.
Two orders are there, Lordship will grant.
Obliged.
Wait, please, your lordship. So here,
Or you can do one thing, counsel.
there are
There is a period, assuming if this, your plea is not accepted and it results in dismissal of the bail application, then you have to go in appeal and it provides a limitation period. So in view of ensuing vacation also, you consider whether it would be more appropriate for you to withdraw this application and straight away go there or wait for the outcome and then go. Because you don't know when the outcome will be available.
Then, my lord, will withdraw.
All right, on the prayer of learned counsel for the petitioner, the matter stands dismissed on withdrawal in order to enable the petitioner to seek appropriate remedy in law. Petition stands closed.
Obliged.
wait, please, your lordship. Here, my lord, my lord, allegedly 4 kg 649 grams of ganja was recovered from the possession of the petitioner, my lord. Now here I am on, my lord, that on the detention period, my lord, B, my lord, lordship knows 20 kg is the commercial quantity. That 4 kg 649 grams is the quantity re-recovered. More than 40 days in custody, your lordship. Considering B, my lord, that only on that he is a local person, my lord. On that ground, my lord, I'm seeking bail, my lord. The length of detention and B and the quantity is far below the commercial quantity.
Yes, PP.
My lord, we have received the case area, my lord. It is pending to collect the FSL report, my lord. Otherwise, my lord, the accused person has been implicated, my lord. It is recovered from his possession, my lord. So let the matter come up on, my lord, on 21, my lord. Not keeping on the exactly on the reopening day, my lord. After a reopening, then we can, my lord, produce the FSL report. My lord.
40 days in custody, my lord. Further detention
So
may not
as I
be.
said that, my lord, he used to do business of ganja, my lord. This is implicated, my lord.
All right, 50 looks better than 40.
Lordship.
List again on learned edition and PP.
Oblige, your lordship. On 21st, oblige, your lordship.
May I please, your lordship?
So 23 searches submitted, my lord.
Is there was
Scan copy.
lordship, here, lordship, if lordship comes to the FIR, lordship, for once there is a violation of illegal detention, lordship.
We need the record.
Can we be called for them?
And copy of search sheet has already been submitted, right?
PS number, my lord, 55/2026, dated 31/3/2026.
The scan copy of the TCR.
21, lordship. Can it be on 21, lordship?
2 days, where do you bicker over 1 or 2 days?
22, lordship. I have 23, I have.
Deeply public.
May I please, Lordship? My lord, item
25
number
25
M40
and 42, my lord. may
out
be
of the
taken
same
up-
affair.
For 25 and 42 may be taken up together, my lord. Arising up to the same case there.
All right,
My lord,
42. Follow up with 42. Not come today, I think.
No, so it is already filed on 6/4.
my lord,
Cover koro, as it is.
May I please, your lordship? Lordship, 483 BNS's application, your lordship. FI is at page number 10, your lordship. Yeah.
Michael was appointed on the last occasion, my lord.
Hmm?
And Michael was appointed on the last occasion. my lord.
Was there, your lordship. Sometime, your lordship.
All right, we'll take up.
Yeah, please, your lordship. We are somehow able to file the reply. Our reply is on the record. Today we have filed. It is consisting of detail his conduct in the scam trade scam. And he has also transferred some amount in his own account that has been reflected in our paragraph number 24, your lordship. Substantial amount. The charge sheet has been filed on 30/3/2026. It is given in page
Let
number.
us have this immediately after Bihu. I don't think if we have to go through it, I don't think we'll be able to cover the items today being the last day.
My lord, the only observation is, my lord, gives, my lord, because the submission was made that charge sheet was filed without investigation being complete.
There is a
On that aspect, my
provision.
lord, even in this written objection, my lord, the same view is being reflected. That is completely contrary to what law says.
Okay, we'll have to examine in detail. So 21st.
As your lordship.
My lord, may kindly keep it as a parted matter.
I have hardly heard this
So
matter.
today only we have filed this. 21st.
Reply has been learned counsel for the petitioners. He has filed its reply today.
My lord, can it be 28th?
28.
20.
But
20.
20 list has already been given. We have 20 cases on that day. So I may, for the time being, I may take it, John, on 28th.
In that case, my lord, 24th.
24th, yes, no problem. Because 20th cause list has already been released.
Obliged, my lords.
Much obliged.
Well, the Bhaskar Sharma is in the case, well, he is coming in court number 6. Has come.
What contempt case?
Yes, my lord, it's a contempt case. An order has been passed for handing, for allowing my Zimna, my lord. And thereafter I approached it for the investigating officer and OC as well as the superintendent of police, my lord. Till that, my lord, Zimna has not been given, my lord. But this is, my lord, notice may be issued, my lord.
This is third learned counsel for the petitioner. This is an application Section 12 of the Contempts of Courts Act 1971. Edit Article 215 of the Constitution. Respect of violation of the order dated 24/3/26 passed by this court in criminal revision petition number 78 of 26. Issue notice. Steps. Register post with ID. Speed post.
My lord.
List again on.
Earlier, please.
May I please, your lordship? Lordship, 483 application, your lordship. FI registered under section 4 of the POCSO Act, your lordship. FI as at page number 10, your lordship. Translated copy of the FIR, your lordship. 10, your lordship, and vernacular portion is at page number 12, your lordship. It's not vernacular, actually, your lordship. Your lordship, charge sheet has
Filed
already
some
been,
additional affidavit.
yes, your lordship, charge sheet has already been laid down, your lordship. Charge sheet laid down under section 8 of the POCSO Act, your lordship. The petitioner behind the bar more than 109 days, your lordship. The charge sheet at page number 21, your lordship. Your lordship, kindly come to page number 21, your lordship.
Yes.
Under section 8 of the POCSO Act, your lordship, the charge sheet has been laid down, your lordship. Lordship, kindly come to page number 25, your lordship. Before coming to the merit of the case, your lordship, some technicalities are there, your lordship. That is page number 25, the last portion of your lordship, kindly peruse, your lordship. Further, I pray before your honorable court that the final medico-legal examination report is still awaited due to the pending Directorate of Forensic Science Laboratory report. Upon receipt of the FSL report, the IO shall submit a supplementary case diary under section 193(9).
Where are you reading?
Yes, lordship, last part, your lordship. Page number 25, your lordship.
Yes.
The last paragraph, your lordship. There is a prayer to file a supplementary charge sheet under section 193(9) of the BNSS, your lordship. Now, if your lordship kindly see 193(9) of the lordship BNSS, your lordship, there is a proviso part, your lordship.
Where is it now? That converted to 8.
Cognizance has already been taken, your lordship. Charges frame, your lordship.
Yeah.
Before
Under
the trial court, your lordship. Now, what is my submission, your lordship? That supplementary charge sheet is yet to file, your lordship. Or some FSL report yet to come, your lordship. Now, if your lordship kindly see 193 subsection 9 of the BNSS, your lordship, there is a proviso part, your lordship, provided that further investigation during the trial may be conducted with the permission of the court trying the case, and the same shall be completed within a period of 90 days, which may be extended with the permission of the court. These two ingredients, your lordship, 90 days time, your lordship, and permission of the court, your lordship, the trial court, your lordship. If your lordship kindly again come to your lordship, the page number 27, your lordship. One order is there, your lordship, that is missing from the your lordship. At the time of filing the charge sheet, your lordship, there is no permission, there is no leave from the court to file supplementary charge sheet, your lordship. That statutory provision has been violated, your lordship, by the investigation agency, your lordship. at the time of filing the charge sheet, your lordship, that is the order, your lordship, at the time of filing the charge sheet, your lordship. There is no leave, there is no permission by the trial court, your lordship, to file further charge sheet, your lordship. Supplementary charge sheet, your lordship.
But charge sheet was submitted,
13, alia charge sheet, your lordship, submitted, your lordship, 16 December, your lordship, 26, your lordship. That is at page number 21, your lordship.
on the basis of which this cognizance order 19/2/26
Lordship,
has been
lordship.
passed.
Yes, your lordship.
Okay, so now we are on bail.
We are on bail, your lordship.
So remaining investigation, whether it is done or not done, we are not concerned at this stage.
But your lordship, what is my submission, your lordship, with due respect, your lordship, because already 109 days behind the bar, your lordship. If your lordship, the investigation agency needs some time to submit supplementary charge sheet, your lordship, there have to be a, your lordship, permission or leave of the court, your lordship. The proviso part itself says. And even your lordship, I'm relying on a judgment of Honorable Supreme Court. This recent judgment.
That argument will come provided prosecution takes that stand. Now you are on merit on the bail.
Merit of the bail, but your lordship, I'm taking this stand also, your lordship, because if your lordship, I'm relying on judgment of Honorable Supreme Court, yes, your lordship.
We'll go to Supreme Court if we have to.
Lordship. Your lordship, that on that ground, your lordship.
Before we see the Supreme Court, we have to be clear about the facts.
Lordship.
Fact is that the charge sheet has been submitted and
Submitted.
cognizance has been taken under
Taken,
section 8.
Lordship.
So we have to see whether there is material warranting your further detention. That is all.
Lordship.
Why bring in all this?
Otherwise, your lordship, if your lordship kindly see, your lordship, because, yes, your lordship, somehow, your lordship, because the allegation is that he is the therapist, your lordship. The petitioner is the therapist. That during the process of therapy, your lordship, he grabbed the private part of the victim, your lordship, who is a student of class 10, your lordship, 16 years, 8 months, your lordship, age, your lordship. And your lordship, some other allegations is also there, your lordship. Now, your lordship, yes, your lordship, it's myself, your lordship, at paragraph number 4 of my bail petition, your lordship, pleaded, your lordship, that accidentally, your lordship, my hand slipped, your lordship. That I admitted, your lordship. It is my honest submission, your lordship, before this honorable court. But if your lordship kindly, because the lordship, this is not a trial, your lordship, mini trial where I can convince this honorable court whether the case is manipulated, your lordship. But if your lordship kindly see paragraph number 30, 32, 35 and 36, your lordship, these are the deposition for which, your lordship, I have filed the additional affidavit, your lordship. There's some contradiction, your lordship, manipulation, your lordship, on the part of the lordship prosecution witnesses, your lordship. At this stage, your lordship, I can't prove, your lordship, because this is not a trial court, your lordship. But to satisfy this honorable court, your lordship, that, your lordship, yes, your lordship, some manipulation is there, your lordship will find out, your lordship. Lordship, kindly come to page number 30, your lordship. Is the statement of the victim, your lordship.
Yes, I've seen it.
Lordship. Your lordship, again, kindly come to page number 32, your lordship. That is 183 BNS statement, your lordship.
Yes.
Again, your lordship, the statement before CWC, your lordship. 35, your lordship, the vernacular portion, your lordship.
Yes.
Here, your lordship, the last part, your lordship, that is 36, your lordship, the vernacular portion, your lordship. Some contradiction is there, your lordship, in their own statement, your lordship. Sometimes he says he latched a door, your lordship. Sometimes say your parents came into the lordship room, your lordship. So at this stage, your lordship, I can understand your lordship. This is difficult, your lordship. But why I am submitting your lordship to convince your lordship? Otherwise, I don't have any materials, your lordship, to convince this honorable court that case is manipulated, your lordship, exaggerated and modified, your lordship. Somehow, your lordship, I have admitted, your lordship. Accidentally, my hand, your lordship, during the time of massage, yes, lordship, accidentally touched the private parts, your lordship. That is not intentional, at least, not at all, your lordship. But the other thing, yes, lordship, that is, lordship, you find out, your lordship, because this is the open court, I kind of read out all these things. So, your lordship, I, lordship, request your lordship to peruse, your lordship, the statement, your lordship, with due respect, your lordship.
This is what we have been
And-
doing all the time, and then everything is consistent
Lordship, or your lordship, the
as far as the main allegation is concerned.
main allegation is, lordship, as per allegation is there somehow. We can prove it, your lordship, during the cross-examination, your lordship. But at this time, your lordship, considering the length of the detention, your lordship, considering, your lordship, that thing, at least, your lordship, that supplementary charge sheet is also the aspect of that supplementary charge sheet, your lordship. And again, your lordship, the, if your lordship kindly see medical legal report, your lordship, that is also.
What will medical legal
Yes, your
report
lordship.
show in an offense of this nature?
Yes, lordship.
Yes, PP.
Regarding submission of my learned friend, my lord, 193.9, my lord. That submission is not correct, my lord, because the search sheet is submitted not in the year December, my lord. Search sheet submitted, my lord, on 16/2/2026, my lord, the month of February, my lord. So after completion of the search sheet, my lord, if the IO prays for, my lord, further investigation, my lord, further investigation, my lord, IO has already power, my lord, that it is not required to obtain any permission from the court, my lord. But, my lord, even it is not completed, then, my lord, he may pay for further time, my lord, and that has to be completed, my lord, within a period of 90 days, my lord. That will be counted after filing of the search sheet, my lord. And regarding, my lord, the trial, my lord, what the trial court will see, my lord, at the time of evidence, my lord. Basically, the 183 statement of the victim boy, my lord, and the 161 statement, my lord. And it is consistent, my lord. Lordship has already gone through, my lord. The main allegation is already, my lord, whatever he has stated, my lord, in the same thing he has stated before the IO also and before the, my lord, judicial magistrate also, my lord.
What I fail to understand is why is the charge submitted under section 8? The offense clearly comes under section 4.
Yes, my lord, then I do not know, my lord.
No, your lordship, charge
Trial-
frame, your lordship, charge frame under section 4(1), your lordship.
Yes, then
Cognizance has been taken, your lordship, under section 8, your lordship. But charge frame under section
Search frame under section 4, my lord.
4(1), your lordship.
Trial will proceed accordingly, my lord.
And
Let the victim boy examine, my lord, after that, my lord.
because it is fixed on 4th of May, your lordship.
Yes.
Because it is not as much, your lordship. Lordship kindly impose any condition, your lordship. Any condition, your lordship. And even, your lordship, 36 arrest memo has been provided without obtaining signature of witnesses, your lordship. It is also there, your lordship. At that stage, your lordship, we can prove. Lordship, kindly impose any condition, your lordship. If your lordship kindly instruct us to attend the police station, your lordship, in alternate date, we will do, your lordship. It's a manipulated story, your lordship. He's the sole honor of his family, your lordship. But considering all aspects, your lordship, my humble prayer, your lordship, at this time, your lordship. Because the evidence is fixed on lordship on 4th of May, your lordship.
Then, my lord, let the matter be fixed after 4th of May, my lord. In the meantime, victim, my lord, boy may be examined.
His lordship,
all right.
lordship.
Instead of us
Again,
forcing you to file another application.
109 days, your lordship. So considering, lordship, any condition, your lordship, will abide by, your lordship. Any condition, your lordship. My humble prayer, your lordship. 109 days, your lordship. There is no flight risks, your lordship. There is nothing, your lordship, such like, lordship. Will abide by any conditions, your lordship. Any condition, your lordship. Any strict condition, your lordship, can impose, your lordship. Will abide by, your lordship. There is no antecedent, your lordship, criminal antecedents prior to this, your lordship. There's nothing like that, your lordship. With due respect, my humble prayer, your lordship, at this stage, your lordship. Because custodial interrogation is also not necessary, your lordship.
Now, the
Considering-
interrogation part will not come.
Your
and
lordship,
only the
considering
trial part.
everything, your lordship. 109 days already, lordship, behind the bar, your lordship. He's the sole honor of his family, your lordship. Considering that thing, your lordship, humble request, your lordship. Please the trial, your lordship, will.
Okay, we'll see.
Your lordship.
Please. It's a regular bail application, my lord. The lordship will see, my lord.
Yes, charges submitted.
Yes, charges submitted. Lordship, may I have a look at, my lord, page 20, my lord, 20, my lord. The inventory, my lord.
Yes.
My lord, the second column, my lord, quantity, my lord, 20.11 kg of ganja, my lord. My lord, so accordingly, the case was registered under, my lord, the commercial category, my lord. Now, if a lordship turns to the next page, my lord, that's the order of the magistrate, my lord, page 21. It starts from page 21, and lordship may come down to page 25, my lord.
Yes.
Page 25, my lord, lordship will see, my lord, 16.2.2, my lord. My lord, the total net of the seized ganja is 16,007 grams. That is 16.07 kg, my lord. So it comes in between, my lord.
Scan copy may be called for, my lord. We'll examine.
Scan copy to ahibo, will not also give for Cobra. So, my lord, it will be in the category B, my lord. And the petitioner before your lordship, my lord, she is a lady of, my lord, 65 years, my lord. And already behind the bars, my lord, for last 55 days, my lord, as on date, my lord.
By the time scan copy comes, statutory
My lord,
period will be over.
only one submission, my lord, if your lordship pleases, my lord. My lord, my son's marriage is, my lord, scheduled on, my lord,
60 days.
60 days, my lord.
Question is, my
Well,
lord,
on
only we have to
14th
verify, my lord, because it is subsidiary case, my lord.
I
We have to rely on the, my lord, scan copy of the case diary, my lord.
I
Whether the contraband is, my lord, is come, my lord, commercial quantity or below the.
That order is there.
He's questioning the, my lord, the order passed by the magistrate, my lord. Magistrate order says, my
I am
lord.
not questioning, my lord. I have to
Then
verify.
how can it, my lord, Dila?
But are you inviting me to the marriage?
Because inventory also. made by the magistrate.
I only want, my lord, interim, your lordship may grant me interim, my lord. Let the case be fixed after, my lord, calling for the diary. If there is anything adverse, my lord.
Both the, my lord, inventory and the order, my lord, both are, my lord, the magistrate, my lord. So we have to rely on both the copy, my lord.
Inventory is prepared by the IO.
Signed by the magistrate.
Signed by the magistrate seen koro. Kine kene bojam tumhara. When the samples are drawn before the magistrate, my lord, it founds to be, my lord, within category B, my lord. It was with packets and everything, my lord. I'm praying only for interim, my lord. If any adverse come, my lord, report comes, my lord. Only for the marriage, my lord.
Then, my lord, the records of 37 will come, my lord. That has to be.
Ultimately, it is B, man.
Once the magistrate has certified under 52A, then we have to go by that. Can you dispute this?
We cannot dispute, my lord, but only one manner I am praying to, my lord. for
Because
the same to be
samples were weighted and measured before the magistrate.
Well, page 24, my lord, he may be, for him, my lord, page 24, my lord, 16.2, my lord.
Assuming, my
Now
lord,
all the marked P1 to P9 plastic packets containing suspected ganja are emptied out into separate packets from A1, A9. To identify the net weight of the seized ganja in nylon Y, which were rolled in newspaper and opened and emptied out in the another, my lord. So it was rolled, my lord, by the paper and, my lord, the nylon paper. So therefore it came down to 16.7 kilo.
But assuming, my lord, it is a intermediate quantity, my lord. Even though, my lord, she is not entitled to release on bail, my lord, since it is charge sheet has been submitted, my lord.
So where is the law, my lord? Where charge sheet is filed, my lord? How can I?
There are material, my lord.
I am paying only my interim, my lord, because of my son's marriage, my lord.
It heard learned counsel for the petition. An application under application as far as the present petitioner is concerned. The present petitioner was apprehended by the police 12 to 6, 13 to 26. 13 or 12?
Actually, my lord, the forwarding is 13, my lord.
12 to 26. Along with ganja weighing 20.11 kgs in total. Was remanded to custody on 26. That has already been submitted in the case. Of the order dated 13 to 26 passed by the learned JMFC Kamrup Metro indicates that during preparation of inventory, Section 52A of the NDPS Act, the net quantity of ganja was found to be 16.7 kg, which should bring the contraband intermediate category. Prima facie, it appears that Section 37 of the NDPS Act would be attracted. Further submitted that the marriage of the son of the petitioner is scheduled on 10th of April. Therefore, learned counsel placed for interim ready. Having regard call for the CD, regard to the provided that the petitioners in bail of rupees 50,000 with securities of like amount to the satisfaction. Judge.
Kamrup Metro.
Madam, my submission may be recorded, my lord, because the charge sheet has been submitted, my lord. The charge sheet number may be mentioned, my lord. And even it is comes to my lord, my lord, intermediate quantity, my lord. Then also, my lord, since the charge sheet has been submitted, my lord, she is not entitled to release on bail. Charge sheet number.
The matter is, even if the quantity relates to intermediate category, the charge sheet has been submitted and is material against the petitioner, indicating that there is material against the petitioner to be released on bail.
Charge sheet number to liquidate. Charge sheet number 20/2026, dated 25/3/2026.
Provided that the petitioner, the jurisdiction of the trial court without its permission.
Surety, my lord. Two surety. I'm obliged.
He was called for use. CD receive, my lord. In fact,
Updated
yeah,
CD
my
receipt.
CD receive, but it is not updated. My lord. Interim order is there on 13/11/25.
CD, updated CD is not available. Interim order passed earlier to continue. List again on.
May.
My lord, item 31 is have CD not,
Item 31 CD not available.
Item
31. It was
CD not available.
everyone is related to this.
no, my lord. No, my lord.
Then call it up into.
That clear. 482 application lordship. FIR lordship will find page 10. Page 10 lordship, 3 accused persons are named here. Lordship will find that accused number 1, that is the petitioner before your lordship. That accused number 2, he was granted regular bail. And accused number 3, he was granted anticipatory bail by this honorable court, lordship. Now, date of lodging of the FIR, your lordship will find top portion 12/5/2025. The informant respectfully begs to state that while I was in Kerala for for earning livelihood on 5/5/2025, that is prior to 7 days, my minor daughter, namely so was going to home alone on the embankment at Mohmari Pathar village. The accused persons, with the help of Taslima Khatun, a daughter of Taijul Islam, resident of Tinsukia, Mohmari, forcefully abducted my aforesaid daughter on a motorcycle. And on the next day, that is on 6/5/2025, at about 12 noon, dropped her near my house. I came to know about the incident from my daughter. So here, why I'm pointing out that delay part, lordship, the delay part, your lordship will find here, lordship, allegation is that 3 persons committed rape on the daughter of the informant. That is the allegation in the FIR after 7 days also. Now, lordship will see that page 21. This is the one of the accused. He was granted interim bail, lordship. That Abu Bakr. And he was subsequently granted absolute bail. That on other day I have provided that copy, lordship. It is there in the record probably. The lordship may kindly see the observations made in that order, lordship. I do not know what is there in the case diary. Now paragraph 6, lordship may kindly see.
Disorder is there. Is annexed here.
No, this is not, this is the final order, lordship, which I have now handed over to your lordship. This is the final order. Final order, paragraph 6, lordship may kindly see. I have heard the parties and gone through the records. Upon noticing the statements of the victim under section 183 of the BNSS, it seems that the victim and her friend had gone to their own on their own volition with the petitioner and others. And it was night time when both the victim and her friend were made to have liquor, and they have themselves admitted that they were sexually assaulted, more so the victim by the petitioner. So that victim which was named in the FIR, she was sexually assaulted by that Abu Bakr Siddiq, who was granted bail, not by the present petitioner. That is why I am pointing out to your lordship. They have themselves sexually, more so the victim of the petitioner, victim by the petitioner, and her friend by another person inside the vehicle. So against me allegation that the other girl which was who is named in the FIR, I have molested her, Lordship. But she has not made any complaint, no subsequent FIR is there, nothing is there, Lordship. Although it is subsequently after considering that
Yes,
he was
anything specific to him?
Yes, my lord. There are two victim girls. Both are around, my lord, same age, around 16 years, my lord. Both are class 10 students. Both the girls were coming from schools to the embankment, my lord. Then this petitioner, Abu Kosor, my lord, he requested both the girls that I will drop in your house and riding in his motorcycle. Subsequently, he came to a place where two other person, that Abu Bakr and another person, 3% get together and they in a vehicle. Malad. Subsequently, this Abu Kosor raped one girl and this Abu Bakr, he raped another girl. Malad. Malad mein perus the statement of the girl. Malad. 186 statement, both the girls are victims. One by Abu Bakr, that person, one is by, and he is the person who lifted the two girls in motorcycle first. Took to the place where that other two persons came in car. I'll kindly peruse the statement, 186 statement of the girl.
Those allegations are not there in the FIR. Therefore, I have pointed out that although incident occurred on 6th, he returned to house on 6th, and FIR was lodged after 7 days. Those facts are not there in the FIR. That I have molested the other girl. That is not there. That is what I am pointing out, Your Lordship. Regarding the victim girl, daughter of the informant, that I am not commenting because already that person is granted bail, Lordship.
Backside, Malad,
Regarding that other girl
is there.
Regarding other girl in the FIR, after 7 days, no allegation. And even she did not file any complaint or nothing, Lordship.
Statement of the other girl Malad, in the next page, Malad. The girl which is involved in the FIR.
The first statement, this Abu Bakr is implicated.
Yes,
Abu Bakr.
Abu Bakr is the person who got bail, Lordship.
Yes. And in the second,
No, that 186 statement implicated the Abu Kosor Malad. Abu Kosor Malad, that Abu Kosor has come in motorcycle Malad.
regarding allegation of rape,
That is Abu Bakr. As per the order.
you were submitting that there
But
is
one girl, Malad mein perus the statement of both the girls Malad.
a কৌশৰ বাইক এখন লৈ আহে According to this, Kosar took both of them, both the girls in a bike.
Yes, his bike, and took to the place where the other two persons came in car, ride together in that car.
Yes, direct implication is there. Kosar is also mentioned here. Mur logot,
Malad, yes.
Hari Vitorat Kosar and Mur logot.
Yes, yes, my lord. And
No, that-
and
that you are
in the statement of that Abu Bakr, my lord, he stated that I don't know that the girl is minor, but Kosar, my lord, my lord, he know those girls. Girls also know Abu Kosar because of that ride in his motorcycle. And Abu Bakr and Kosar, these are not the similar footing, my lord, because he, my lord, convinced that two girls that I will drop in your house, and they ride in the motorcycle, my lord. Subsequently, to an anticipated bail for this person's, my lord,
Regarding that, Lordship, the three
important
persons were
subject.
named in the FIR. And
In fact, my lord, in fact, it all. Bail. October. In fact, allegation against that particular person is made.
that is the submission of the PP.
Submits that facts have taken up the investigation. It was got pregnant, and thereafter the police provision under the POCSO Act, more specific. Withdrawal, he might have suppressed these minor provisions, and minor he might not edit informant as the party. Why you drop these sections of in your bill application? What? The name of the informant has been added in the bill application. And no notice was issued, my lord. So in that way, he got the interim protection. So that is his main case. And your lordship will see, it was found out that the victim got pregnant, and thereafter the police under section 46 POCSO Act. He produced the statement of the victim, in which she has clearly stated that it was the who sexually assaulted her after she was intoxicated. They administered some substance. That it was petitioner who said.
Okay, we'll wait till,
on 27, my lord.
yes, she did not receive list again on 26.
Maybe 22nd lordship.
22nd, no. What was it? 27 question.
Obliged.
No. No, sorry, my lord, here, I was seeking time, my lord, because of the election duty, my lord.
The second time, Lordship, there's a petitioner is the register, owner of the vehicle, Lordship. He is not involved in this case. His vehicle was hired by one of the cattle certificate holder of the, kindly see the page, file is the 15, Lordship. He is the owner of the vehicle where the cattle was transport, Lordship. And while cattle was transferred, the veterinary doctor certified that there is a fitness certificate was also issued that the cattle is a fit to travel, Lordship. I have annexed the fitness certificate also, Lordship, which is that is page number 22, Lordship. Thereafter, both the owner of the vehicle and cattle owner filed a Zimma petition before the learned GMFC for Zimma for Zimma. Thereafter, the learned GMFC already granted Zimma for the vehicle as well as the cattle, Lordship. That is page 25 is the Zimma order, Lordship. Petitioner is the registered owner of the vehicle. He cooperated with the
All right,
investigation.
heard learned counsel for the petitioner. Additional PP submits that CD has not been received, and IO has sought time to produce the case diary. Submitted on behalf of the petitioner that petitioner is the registered owner of the vehicle which has been granted in Zimma to him by order dated
By order dated Lordship 13/2/2026, Lordship.
13/2/26 passed by the
Learned GMFC Hazul, Lordship.
in regard to the above, it is provided that in the event of his arrest, petitioner should be released on interim bail of ₹1,000 with one surety to the satisfaction. Directed that the here before the IO period of 14 days along with all necessary documents for the purpose
Much obliged.
of Taken on
11th of May.
Much.
CD not received, my lord.
they did not receive list again on. So and so
11th of May.
interim order passed earlier to continue till
All right. Let's see, my lord,
Wait, please, your lord. Mr. POCSO, my lord,
notice
case, my lord.
not, sir.
not returned.
Oh,
You are appearing.
My lord, page 8, my lord, is the FIR, my lord. Small FIR, my lord. My instruction is that, my lord, as and when the girl attains the majority, my lord, major, my lord, they are going to, the marriage will be solved, my lord.
Yes.
14 years, 6 months, girl, my lord.
Has been amicably settled in presence of the, and they are going to marry each other after attaining the age of the victim. At this step, I have no any objection.
My lord, the girl, 14 years girl became pregnant. And POCSO, my lord, is between, my lord, the accused and the government, my lord.
The only way I am involved is that, my lord, I belong to the same locality, my lord.
But in this case, my lord, yes, 3 persons were arrested, suspected to be rhino elephant possessed, my lord, and the elephant, when found, my lord, teeth, tongue, these were, my lord, amputated, my lord, these are cut. But the statement of all the 3 co-accused, my lord, who were arrested, my lord, they have not taken the name of this person, my lord. Someone is, someone has
Great
found-
hard learned counsel
why
for the
he is apprehending, my lord, I don't know, my lord.
petitioner. Learned additional PP. Then application under so and so. As per the allegation. A, a dead elephant was found lying inside the forest area at Manas Part 2 near Koraibari Village Road. And it appeared that the elephant had died due to poaching by gunshot. And the body parts of the dead elephant had been removed. There are 3 persons who were arrested on suspicion. Is submitted by learned additional PP that the statements of the said accused persons, arrested accused persons nowhere indicates the present petitioner. However, the petitioner apprehends arrest. Yes, where do you apprehend arrest?
My lord, I have mentioned in para number, my lord. Page number 6, my lord. Para number 3, my lord. The last paragraph, my lord. Further, the investigating authorities have visited the house of the petitioner
Yes,
several times.
apprehends arrest as the investigating authorities have visited the house of the petitioner several times. In regard to the available material, the prayer for pre-arrest bail is allowed. The petition, in the event of his arrest, shall be released on 50,000 security like amount to the said testing authority. Connection with the aforesaid case.
Highly obliged, my lord.
Subject 5, my lord, I was seeking another date due to the, my lord, election. CD is not available.
Lord. Actually, the co-accused have been granted bail, my lord. They were in custody, and Lordship may kindly see page 20. There is the observation of the learned session judge. Kindly see page 20, third para. Perusal and consideration further revealed that materials on case diary so far collected by investigating officer points out that investigation has sufficiently progressed. So, my lord, may I hope that and at that time, that is on 9/2/26, and today is 8/4. So further progress is there. So at least interim protection lordship may kindly provide it.
Wait, this was earlier rejected after perusal of CD.
Yes. But
Then we'll have to wait
this
for
order
the
has
CD.
been passed later on.
That is considering length of detention also.
Yes, that's it.
CD not received, list taken on.
Court.
Four.
Court May.
4 5. Good enough.
এই ভোট ফিক্সে আছে
Hello?
on 30th of April.
Sorry.
Yes, submitted. Sophia Roman, no?
So scan copy.
He may approach. No, he will approach, right?
Will approach. At learned counsel for the petitioner, learned additional PP submits that CS has been submitted wide.
Yes, number 86/2026, dated 31/3/26.
It is submitted by learned counsel for petitioner that the petitioner shall appear before the learned court below and apply for regular bail. Accordingly, petition stands closed with the observation that as and when any such application is made before the learned trial court, that same shall be disposed of as per law. Complaints.
37, I'm sorry, my CD not received.
Made with your lordship. FIR lordship will get at page number 11, your lordship.
It is the first date.
Yes,
On 20th of March, CD was called for. Since it was from a distant place, almost 20 days was given, your lordship. And both these petitioners are no longer in the place of station, your lordship. They have been transferred and they are now in their respective place of posting. They are under the police department itself, your lordship. I'll just take your lordship to the FIR at page 11. With due respect and humble submission, I wish to state that on 2/2/2026, information was received from a reliable source that several under trial prisoners and convicted prisoners were conspiring to escape from jail custody by using communication devices inside the campus of Sribhumi District Jail. Accordingly, GD entry was made. Following instructions from superior officers to inquire into the matter, I so and so, along with other police staff, left PS on so and so by GD
No,
entry.
who has been transferred?
Now,
You, petitioner.
Both these petitioners serving at that time as assistant jailers, your lordship.
At that time.
At that particular point of time, they are serving as assistant.
Where are they today?
Lordship. Now I have annexed the transfer order at page number 15, your lordship.
That means you have no apprehension at the moment.
Lordship. Still, your lordship, we don't know.
They did not receive list again on.
So lordship may kindly consider the interim. See, their statements have already been recorded, your lordship.
Don't see any apprehension on your part anyway. You're working pretty well.
We are working, but there is a scope, your lordship. They are new officers, your lordship. If in case they are arrested, your lordship, they have already recorded their statement, your lordship.
Then
they will also appear, your lordship. There is no chance that they will escape.
You appeared, your statement is recorded, you are allowed to go. Where is the apprehension?
Thereafter, your lordship, what happened? Section 7 has been added, and therefore the petitioner apprehends that they may be arrested, your lordship. By way of a subsequent application at page number 13, the IO has added section 7 of the Prevention of Corruption Act, your lordship. This has been done on 10th of March
If
2026.
there is materials, my lord, we have to peruse the CD, my lord. Without perusing, it is difficult.
No, if it is there, your lordship, they are police officers, they are under the authority, your lordship, they have already been transferred. There is no question of hampering or tampering with the intelligence also, your lordship. They are very new recruits, your lordship. They were working under the jail superintendent itself, your lordship. And they have been made Caesar witnesses also in the case. Kindly consider, your lordship.
Wait for this much time. This is
29, my lord.
leave earlier. 24.
20th, my lord. 24th. Immediately, it is difficult. 24th.
Oblige, lordship.
39th, sorry, my lord.
One person is not interim lordships. Kindly have a look at page 13 lordships.
One person got in, one
Two are in interim, one is not interim. Page 13 is the affair lordships. Custodial integration may not be required lordships. Kindly see, my lord. Page 13 lordships. And my lord, I have received the notice of the police 35 lordships. So man, I want to appear before the police lordships. Right? I want to appear before 35 has been issued to me lordship.
notice, if 35th notice is there, then
So
application is not there.
I was, that's why when I am, only some protection may be granted lordships. I want to appear lordship.
In both cases, my lord, if notice not issued, then also apprehension. If notice issued, then again
Yes,
apprehension.
I want to appear, I want to cooperate lordships. Only some protection may be granted lordships.
Already 2% on my lord, interim is there, my lord.
Yes, one is not interim lordship. So I want to also cooperate lordship. Only some protection lordship.
The learned counsel for the petition has called for has not been received. Again on so and so in regard to the fact that other co-accused persons have been granted interim protection, and having regard to the nature of the allegation as well as the fact that present petitioner number 1 has received notice under section 35 BNSS, provided that in their arrest, the arrest petitioner shall be released on bail of rupees 10,000 with 2 sureties of like amount to the satisfaction of the authority. Directed that the petitioner shall appear before the IO pursuant to received under section 35 BNSS on the date fixed and with the investigation. Again on
I'm obliged.
That's 42 and 25.
42, 25.
Right, my lord, kindly take the item 25 first. Lord, this is regular bail application, my lord. I have been arrested on 21/3/2026, my lord. FIR is at page number 10. Relevant portion 3, my lord, 10, page number. Lord, page number 18 is the cross FIR, my lord, filed by the instant petitioner.
Yes.
That both sides made allegation is against each other, my lord. Perhaps, my lord, investigation also substantially progressed, my lord. So further custodial detention may not be perhaps required, my lord. And the accused person in cross case already granted interim pre-arrest bail, my lord. FIR lodged by us, my lord.
They have received the case diary, my lord. The allegation is that, my lord, the victim, my lord, he was assaulted by 10 to 12 persons, my lord. Now, my lord, we have received the case diary, my lord. There, but the victim statement is not in the case diary, my lord.
And whose statement is there?
Sustained injury, my lord. His
My lord,
statement is not there.
Team is not there, then what is the meaning of the case diary?
My lord,
There
this,
is other-
my lord, this is the interim bail in cross case. The alleged victim in the instant case. ma'am.
They are your opposite party.
Our opposite party. ma'am.
Yeah, FIR is the counterpart of our FIR. Lordship. The page of page 38 is the first medical report. After they assaulted me with.
They have been granted interim protection. That means their case is better than your case.
No, my lord, on the same date, both the FIR lost on the same date, my lord. Jitu Das also lost the FIR on 8/3/2026. Bobul Mahanto also lost this case on my lord, 8/3/26, my lord.
What is any injury report is there?
This is 27 instances.
Injury report we have received, my lord.
I have
that
also sustained street injury.
expert is
Yeah, I have annexed medical reports, my lord. My lord, page annexure 4, page number 20 to 27 onwards, my lord. Both parties sustained injury. But what happened, my lord? There are going some land dispute between both the parties. This is admitted fact. We are also 15%, they are also 15%, 15-16%, my lord. Perhaps both parties involved in close market, my lord. Joint market.
it is no doubt, my lord, there are some market between.
There is only in case of Pranab Mohanto. What about other no injury?
Other person, my lord, he may not sustain any injury, my lord, because there is no such injury report in the case diary, my lord.
Have approved the one rejected on 28th of this last month. I'm not mentioned in their petition.
Is it mandatory?
After, no, it is my submission. That is, that
why?
was rejected, that after observing that they're in their material against the present petition. It's on page 53 of my objection. Page 53, Lord. It is B 22. It is not mentioned. Trial court observation is on page, para 6, it is page 55. Result of the case that reveals sufficient incriminating tales against the accused petitioner. The mere fact that the petitioner has also filed an FIR against the informant's brother is not sufficient to enlarge the petitioner on bail. Custodial interrogation of the petitioner, unearthing the facts and arrest bail, petition of the petitioner Jitu Das is rejected.
And now I am paying for regular bail application. Now I am paying for regular bail.
It is not.
That is not the anticipatory bail, my
It
lord.
is not mentioned.
Okay, I have only lower court's rejection order is necessary.
Instruction to mention is
Then-
mandatory. The petitioner has mentioned only the administrative report on the date of production which was rejected.
Then he has, my lord, then he has to follow
why
section
not
301 of
acknowledge
CRBC, my lord.
like that?
He has not followed the section CRBC, section 300 CRBC earlier provision. You can only assist the APP.
However,
You should
I
not
got
forget it.
previous injury lawsuit, medical reports was lawsuit for one, all our medical documents. Page 38 is a Bobo PhD. In last line, it is dressing plus stitching down. Next lawsuit, I came to Apollo Excel Care Hospital. There also CT scan was done lawsuit. Then see lawsuit page 41, it is Winthrop Hospital lawsuit. Here it is stated 9 stitches removed from the frontal parental region of scalp, 3 stitches removed from occipital region, and as the done today, it is on Winthrop Hospital. And later on lawsuit, it is again the discharge certificate of the Winthrop Hospital, the case summary. Patient Pranav Mahanta, age 58 years, was admitted physically assaulted on 17/20/26 at 8 p.m. at Boko. The patient took initial treatment at Apollo X. This done in Boko PHC, a deep cut injury on peritofrontal occipital region and led by small cut.
What is your date of arrest?
My lord, 21/3.
Huh?
21/3. 19 days.
The latest lawsuit, the one CT scan was done lawsuit, the last observation lawsuit. Multiple repeat of opaque foreign body in the parietal and left temporal scalp. As I taken instruction from the doctor, substance, I said this is not part of bodies that Kisuma hard substance inside the
My lord, police referred him to GMCH. Why he has not?
it is on report lawsuit.
On a
It's page
GMCH, madam.
47. Doctor's report lawsuit.
My lord, kindly consider length of detention as because our opposite
Yes,
party
yes,
got
yes.
anticipatory bail, my lord. I am behind the bar.
It is not the first.
Since
case
my lord,
lawsuit.
so my lord, kindly, at any condition, my lord, for the remaining investigation, I will cooperate with the investigation agency.
Earlier I have lost some paint citing their names. It was I have forwarded it to SP. I have mentioned in my objection is page 36, para 13. I have specifically stated. I have also mentioned the phone number of the. Actually, I do not know whether it is registered or not, whether the entry or.
So further custodial detention perhaps may not be required
Having will also the.
because no due fact will come, my lord. So, my lord, at any condition, my lord, I will cooperate with the investigation. At any stringent condition, my lord.
Also in Bokul also, I have a plot and try to have this for that. Try to kill me,
Oh, my lord.
this time they try to kill me, somehow I escaped, Joseph. When somehow all the sections are the punishments are all the life and more than 10 years. 118 subsection 2 laws, it is 310 subsection 2 it is Gauhati laws, it is life. 109 is attempt to murder. I have also bullet injury, lordship.
My lord, FIR itself is silent, my lord, that the victim sustained bullet injury, my lord. Why you are misleading the court?
It is not
FIR is-
decided, I can.
No,
reflect all
no.
the things in.
The informant categorically stated in his azhar that the Pranab Mahanta informed him. So why you are misleading?
The definition of
No.
FIR, lordship.
Yeah.
FIR disclose nothing, lordship. You have one line, maybe.
No, no, this is not encyclopedia.
No,
There is no any specific allegation against bullet injury.
if you write one line complaint, that is also considered as FIR.
I have not denied that,
Then.
learned friend.
That's all, lordship.
Why you are misleading that?
It is not a fact of misleading. It's a matter of record or matter of law. There any
The guy shooting injury, the medical report produced by you.
Jamabandi also, lordship, it is
For
page.
the petitioner. The
S49 is a amount of my land. Is this my factory?
As per allegations. This is an application under the brief facts of the case are that page 53, paragraph 3. Page 53, para 3. Okay. When of the same, there appears to be incriminating materials against the accused petitioner. However, the report in respect of the victim Pranab Mohanto does not indicate any grievous, but only simple injuries. The informant has submitted an affidavit enclosing further medical reports, including scan done in a private hospital, but therefrom also no grievous injury is discernible. Where the nurse herein had also fire against the informant side of the case. Of the same incident. The petitioners were arrested on
Other petitioner is not arrested, my lord.
dishonor.
42 is a my lord, AB my lord.
Dishonor who is
Item number 25.
25 only arrested, my lord.
yes Jitu Das.
My lord.
Hmm?
Jitu Das.
Petitioner was arrested on
21-3, my lord.
by now has spent around 19 days in custody. In regard to the above, further detention of the petitioner is not considered necessary. Accordingly, the prayer for bail is allowed. Ransom shall be released on bail of rupees 50,000. Securities of like amount to the learned. This before
Before Ghulam Mustaq. My lord, JMFC GOPCO, my lord. Judicial Magistrate First Class GOPCO, Kamrup.
it is further provided that on release of the petitioner, he shall not attempt to threaten or intimidate the informant or any witnesses of this case. Will not try to contact them in any manner. Event any such attempt is made, the bail granted to the petitioner liable to be cancelled. Accordingly,
My lord.
this is for whom?
Ghulam Mustaq Ahmed, my lord. Friend of Jitu Das, my lord.
My humble submission only, my lord, this victim statement is not there, my lord. The other person's statement, my lord, they have only said, my lord, I have seen, my lord, some persons are asserting, my lord, this Pranab Pathak, Pranab Mohanto and another person, my lord. It's not specific, but that may be, my lord, mentioned.
In the AB,
AB, my lord, yes.
victim statement is not there.
Not there, my lord, that may be mentioned in the, my lord, BA also, my lord. Because without the victim statement, my lord, although the medical report says, my lord, the injury is simple and caused by a plan, my lord. But without the victim statement, my lord, it is difficult, my lord. That may be recorded, my lord, in my submission.
Victim statement is not there in when submitting the CD. Whose fault is that?
It is, my lord,
Can't hide behind your own lapse.
whether, my lord, it is not recorded or, my lord, it is
No,
not.
I went to the police station after getting interim lordship. They have reported lordship. The IO, I forgot.
No, this AB is for the co-accused of this BA.
My lord.
Yes.
No, then what are you submitting about yourself?
His submission is that, my lord, in other cross case, my lord, when he approached, my lord, for anticipatory bail, my lord, then he appeared before the IO, my lord.
Why is that relevant?
I have also, my lord, flag marked the relevant personal statement, my lord, who has seen, my lord, that the assault, the assault place, my lord.
Was this grievous injury lawsuit? How would the police? Grievous means scale means 27 stitches given.
27 stitches doesn't translate into grievous injury, counsel.
The deep cut injury.
Don't try to become a doctor. Go to definition of the grievous injury.
Cut injury is dear loss. Is that
All right, as far as AB is concerned, you get statement of victim.
Till then, interim may be given, my lord.
Up to that city, we have to call for, my lord.
Till then, my lord, interim may be. Action may be given.
also there is
AB 694 of 26. Learned counsel for the petitioner. Learned additional PP submits that although the CD is available, the statement of the victim not available. Full stop. So it is not understood as to why the IO has submitted the CD without closing the statement of the victim. One further chance is given to the IO to get the updated CD inclusive of the statement of the victim. List again on.
Boko PS, my lord, we can get it. Some protection may be given, AB.
Yes, next item.
My lord, can it be possible or a little bit earlier if interim not given, my lord? Can it be possible? A little bit earlier, my lord. 11. Valuable.
Wait, please, Your Lordship. It's a regular bail, my lord. Here the petitioner was shown arrested, my lord, page 18, my lord. He was arrested in another case, my lord, and accordingly he was shown arrested.
Yes.
My lord, the police, after investigation, my lord, filed the charge sheet, my lord, that your lordship will find at page 25, my lord. The operative part, my lord, your lordship will see, my lord, at page 27, my lord. 27, my lord, Ramesh Ali, the petitioner.
This item?
Item 52.
Yes.
my lord, page 27, Lordship will find, my lord, Ramesh Ali, my lord. He is arrested, my lord. Charge sheet is laid against him. And the next page, my lord, one Lutfur Rahman is there, my lord. My lord, he has been shown as an absconder.
Yes.
Now, my lord, the charge sheet is laid before the, my lord, magistrate court, my lord. It is yet to be committed to the sessions tribal case, my lord. It is yet to be committed, my lord. So today I am behind the bar for 94 days, my lord. My lord, my instruction is that, my lord, although I have not gone through the, my lord, TCR, my lord, it says, my lord, that the arrest memo is not available.
Have you gone through the?
Arrest memo is not there. And, my lord, one more thing, my lord, my friend has, my lord, flag mark one, my lord, page 59 of the TCR, my lord. My lord, that section 48 notice, my lord, W2 message has been sent only, my lord. Blue color flag, my lord. Only W2 message, my lord.
What is the offense?
My lord, regarding, my lord, ATM fraud, my lord. The allegation is that, my lord, they go to the ATM, my lord, and the person who comes to withdraw money, my lord, they somehow, my lord, manipulate them and withdraws the money.
Yes, PP.
Days, my lord, 94 days.
There is some confusion with regard to the scan copy, Lordship, because
Because he heard us in the
the item number is 52. Scan copy of this case is annexed to item number 11, which has already been disposed of. So I'm just understanding what has happened.
No, my lord. In fact, my lord, what happened, my lord? This case was initially tagged, my lord, with item number 11, but it was wrong, my lord. So in the morning when this item was called, my lord, I mentioned, my lord, that the TCR of item number 52 was with item number 11.
What is your name?
My lord, Ramesh Ali, my lord.
But this WT message is with regard to Rinku Islam.
That time, my lord, I'm sorry, my lord, I have not gone through it, my lord. Rinku Islam, Rinku Islam is his brother, my lord. The sent, my lord, he had not received it.
Oh, no, it says, please inform. Islam, son of Kitab Ali, that his brother, namely Rinku Islam, has been arrested.
And the arrest memo is also
But
not.
where has it got to do with Ramesh Ali now?
Go through it, Lordship.
What is the case number?
Lordship.
PRC 18/2026.
18/26. Relation to Bichini PS case 132.
Case number is okay. Is Rinku Islam a co-accused?
My lord, Rinku.
Is there any co-accused?
Yes, my lord. The co-accused, my lord, is, my lord, one Lutfur Rahman. He has been shown as an absconder. That is at page 28, my lord.
Lutfur Rahman is there, one Ziaul Haq is there.
Three accused, my lord, three accused. And Noor Ali, my lord, he has been not charge sheeted, my lord. And Ziaul Haq is also not charge
Lutfur
sheeted.
Rahman,
Page 28 and 29.
Ramesh Ali.
Ramesh Ali is before your lordship.
This does not relate to any of them. It relates to Rinku Ali.
Yes, my lord. Nothing is there, my lord.
I mean, wrong, Lordship. This present petitioner is involved in 8 other cases. Similar nature, and 4 of them has already been charge sheeted. 4 are still under investigation, Lordship. Lordship will kindly peruse order dated 17/1/26.
Right now we are on this, whether this is the 48 notice in respect to, apparently not.
In some confusion, Lordship, regarding the records, Lordship, because
Case number is same, but it is given to 48 notice is given to somebody else.
whether it is in relation to the present petitioner, Lordship, that My lordship.
Equally is nowhere in the charge sheet. So what order are we supposed to pass today?
Lordship will kindly bear with me and just a few minutes.
Let him go through it, my lord, after 5 minutes.
I am for respondent, my lord. She will sole respondent. Already please admitted, my.
TCR not received. Till now TCR is not received. What is this? None appears for the appellant. Learned counsel presenting the respondent is present. As per office note, TCR is yet to be received. The TCR was called for way back in the year 2018. But the till date, same is yet to be received. The learned Kamrup Metro from where the TCR is.
Also, in this matter, the trial court records were called for, lordship.
Let's see. The learned CSM Kamrup Metro, where from the TCR is sent is directed to make an inquiry in order to locate the aforesaid TCR and send it expeditiously. The registry of this court. The next date fixed. Or to submit a report case by the said that the TCR cannot be traced. Communicate a copy of this order to the learned CSM Kamrup Metro. The matter again on
Lordship, I am appearing for the petitioner lordship.
third learned counsel.
PN Sarma. PN Sarma. Public.
Please, Lordship. Here in this case, Lordship, I am praying for correction of some inadvertent mistakes in the order passed by your Lordship in Lok Adalat, Lordship. Lordship, the appeal has been settled in Lok Adalat at an amount of rupees 21,75,000. And out of that, the appellant insurance company deposited 10,94,680, and balance amount of rupees 10,80,320 was directed to be paid. And out of that balance amount, rupees 3 lakhs, 1,50,000 each was directed to be fixed in the name of the two minors, that is respondent name, claimants number 3 and 4. Lordship, after going through the judgment order, I found some inadvertent mistake, Lordship. Lordship, can you see second paragraph? The settlement has been made at an amount of rupees 21,75,000 only, out of which rupees 10,94,680 was deposited earlier. At the time of filing of the claim petition, all the 3 children of the deceased were minors. Then, since then, here Lordship, it should have been now. The appellant number 2, Emmanuel Lal Sungguan, has attained majority. And again, Lordship, at paragraph, third paragraph, out of the ordered amount already deposited by the insurance company, here fixed deposits were made in the names of the then minor children. And it should have been no fixed deposits, Lordship. And again, in same paragraph,
Which are you reading page?
Lordship, page 9.
Just read again.
From the beginning, Lordship.
The first paragraph, no problem.
The second paragraph, out of the award amount already deposited by the insurance company, fixed deposits were made. It should have been no fixed deposits. And again, in fourth line, passed in IA civil number 6502025. It should have been 6562025. Again, Lordship, fourth paragraph, it appeared that although the learned tribunal had directed for making fixed deposits of rupees 2 lakhs each, it should have been 2,50,000. Again, Lordship, in the same paragraph, sixth line, last line, the claimant number 1, appellant number 1, it should have been respondent number 1. Lordship, I have mentioned it in details in paragraph 3, Lordship, at page 5, Lordship.
Yes, counsel.
Sir, all regarding lordship, the apportionment award lordship themselves.
So we can make these corrections.
Yes, sir.
Counsel for the petitioner and respondent insurance. IA has been preferred seeking correction of certain mistakes and omissions. The order dated 14/3/26 passed in the Lok Adalat held on that day. In MSc Appeal number 77 of 2025. Perusal of the IA, the following corrections are now directed to be made, are hereby made in the aforesaid order dated 14/3/2026. The fourth and fifth lines of the second paragraph order, comma, in place of since within quote, since then the appellant number 2, Emmanuel, has attained majority, comma, shall be read as now the respondent number 2, Emmanuel Dal Chungwang, has attained majority. At page 5. The second ABCD you incorporate that way. Okay. Case of this even in bold. Up to F. Paragraph F.
That has been omitted, Lordship. In fact, out of the amount of balance amount of 10,80,320, rupees 3 lakhs has been fixed.
It is further clarified that out of the remaining amount of rupees 10,80,320, an amount of rupees 7,80,320 is to be paid to the claimant stroke respondent numbers 1 and 2. Rest from A to E, do it as per page 5. Hence disposed of accordingly. This order shall be read as part of the order dated 14/3/26.
Obliged, Lordship.
Obliged, lordship.
Hey, please, Your Lordship. Anticipatory bail application. POXO is there, so notice will go in case there may be control.
Pardon, counsel. Call for the CD, issue note number 2. List again on.
Deep revision.
WP message was sent to the brother of the petitioner also. WT message was sent to the brother of the petitioner Lordship. And Lordship will kindly.
The name of the petitioner should have been mentioned as Ramesh Ali.
No, Lordship, it was addressed to his brother, Lordship, because it is a 48 notice. So it was addressed to his brother, Lordship. Lordship will kindly take note of order dated 8/1/26 and 10/1/26. I have flagged mark, Lordship. 8/1/26 and 10/1/26. 8/1/26 in the second page, Lordship will see the IO has communicated. The paragraph starts with the IO has communicated the grounds of arrest under 47 and 48. And second paragraph, Lordship will see IO cell further furnished compliance report. That Lordship has found it. Lordship will then turn to the order dated 10/1/26. 10/1/26. Then Lordship will see. Then Lordship is found, will find Lordship, IO has produced the notice under 48 duly served upon the family members. And he was also asked, Lordship, he has stated these family members will engage their own counsel, Lordship. That apart, Lordship, my submission will be, Lordship, he is involved in a number of cases, 8 cases, out of which 4 have already been prosecuted and trial is going on. And this is the racket, Lordship. I can point out from the petition itself, Lordship, that it is a very big racket that is going on, Lordship. Evidences are against him. So at this stage, it may not be allowed, Lordship. And Lordship is also Peru's order dated 17/1/26. I have flag marked. After section 111 was added, what is the observation of the concerned court, Lordship, at the time of adding of this section, Lordship?
Yes.
Also, my submission is that, my lord, the petitioner is behind the bar for 94 days. And secondly, my lord, in the charge sheet, my lord, there are one other accused, my lord, who has been shown as an absconder, my lord. So, my lord, the case is yet to be committed, my lord. So until and unless he appears, my lord, the case will not proceed. And third submission is that, my lord, so far the arrest memo is concerned, my lord, it was not served, my lord. And the 48 notice, my lord, my friend is saying, my lord, although I have not gone through the record, my lord, there is no signature of that Rinku Singh or Rinku Singh, no, Rinku, my lord. There is no signature of the relative, my lord. That much, my lord. Otherwise, I will be behind the bar unless and until the other accused appears, my lord, the case will not proceed, my lord.
What happened to the arrest memo? There must be an arrest memo at least. Either while scanning, it has been left out somewhere or
Something.
huh?
So arrested, but maybe something is missing there, Lordship. Lordship, all the pages of the CD is also not there, Lordship.
All, my lord,
Even
47.
if shown arrested, there will be an arrest memo.
Yes, my lord, exactly. The signature in the 48 notice is not there.
But I think we'll have to call for the arrest memo otherwise, because as it is reflected in the magistrate's order that has been served.
Or otherwise, my lord, only one thing, my lord. The IO has prayed before the, my lord, magistrate, my lord, on, my lord, 5/1/26, my lord. 5. Immediately after 5, my lord, whether any order, my lord, after 5/1,
5?
I-126, the prayer was made by the IOTO, shown as prayer for shown arrest, my lord.
This prayer is allowed by order dated 8/1/26. He was asked to furnish compliance report regarding furnishing of 48 notice. Then that was done, I think. By the next order, it is reflected.
But the signature is not there, my lord. Acknowledgement, my lord. Signature means, my lord, the acknowledgement is not there, my lord. Excuse me, no?
Which notice we are talking of? IO has produced the notices under section 48. It appears the same are duly served on the family members of the accused persons. Let the same be tagged with the case record. From where from has he said that?
There is that notice, Lordship, in the,
Hmm?
I have flag mark, Lordship, 48, 47, 48 are there, Lordship.
I am nothing, my lord. If there is an acknowledgement, my lord, I no submission is there, my lord.
Yes, signature is there.
Of the,
Rinko Islam.
then I have nothing to say, my lord, on that ground, my lord. But arrest memo is not there, my lord. And the most important part is, my lord, the co-accused, my lord, who has been shown as
No,
an
at this stage, we'll call for the arrest memo,
my lord, if any, my lord,
if any.
if any, my lord.
Third learned counsel for the petitioner and learned additional PP. Perusal of the TCR, it is seen that the arrest memo is not available therein. Although the petitioner was shown arrested by order dated
8-1.
8, yes. 8/1/26. Hence call for the scanned copy of the arrest memo, if any. List again on. So.
And it be আগুৱাই দিয়ক সোমাই আছে ন বহুত দিন বা 24 তাৰিখ মানে দিব পাৰে I am obliged.